Adjournment request, if any, from item number 1 to 5. From item number 6 to 13.
May I please your lordship? I beg to mention item number 23.
6
It
to
matter
13.
maybe come up after 4 weeks because
1 to 11. First they have asked for that.
6 to 13.
6 to 13.
May it please your lordship. I beg to mention item number 11.
Why?
Item number 11.
Why?
With the consent of the other side, lordship, let it be taken.
What is in it? Yes.
appeal filed by the Food Corporation of
Only
India.
with the, but that opportunity should be granted to you to file.
Yes, my lord. Exactly, my lord. A
What's
small
wrong with
issue.
that?
There is,
Whatever the demand they have raised, that has been set aside, that no opportunity was granted to you. Let them give a show cause notice to you,
Yes, yes.
have an opportunity and then respond to it.
lordship, kindly give 1 week, lordship.
Why? What's the, there's nothing in this.
There is some
Otherwise,
difficult.
we are not interfering in the impugned order. We are simply granting them liberty to give a fresh show cause notice, a fresh show cause notice to you and pass order in accordance with the, after providing opportunity of hearing to you. There's nothing in that.
Her senior is not today here. So
When is
let
he?
it be on Friday, my lord.
Friday is not available. Other is 23rd.
There's nothing in this. Why you are
23rd.
seeking adjournment?
Friday, it's okay. 23rd.
Okay, this on Friday, you prepare your matter on that day. Ask your senior, you argue the matter. Friday,
Right.
6 to 5.
yes.
From item number 14 to 25. Adjournment request 14 to 25.
May I please your lordship? I beg to mention item number 23 and 24. This matter may be come up after 4 weeks because the arguing counsel have some personal difficulties. So matter may be come up after 4 weeks.
Leonard Single judge has given enough reasons for cancelling the tender.
My lord. I'm for the respondent number 5, my lord.
And the request is made on behalf of the respondent number 5. The counsel for the appellant has no objection. So the request is made on behalf of the counsel for the respondent number 5 for adjournment. Counsel for the appellant has no objection. List in the month of September.
Obligement.
May it please your lordship. Item number 17, kindly adjourn the matter only for
Item
today.
number
17.
17.
With the consent of the other side.
Same pattern with the consent of the request of the adjournment.
Lordship,
September.
kindly fix it on next week.
September adjournment, then all matters will go in September.
May I please your lordship? Your lordship, I beg to mention item number 6.
6,
Only 6.
only 6.
Item number 6. Your lordship, that the learned advocate from the opposite side is undergoing call and operation, your lordship.
What the review
Matter may be taken.
in September? The request, concept of the review petition. The applicant has submitted that. The arguing counsel is undergoing treatment. And therefore matter may be adjourned. List in the month of September.
Adjournment request from item number 26 to 33.
May it please your lordship, with the consent of the other side, I beg to mention item number 33. The matter may be adjourned.
Adjourned.
May I please the lordship, item number 26, my lord, we need to file a reply.
26.
The other side is there.
compensation, you have not been able to prove the damages up to 23 lakhs, they have reduced it. You are for the appellant,
No, respond.
respondent. What's wrong with the order?
This national commissioners, they deducted without any
What was the- what
showing
is the
any reason.
evidence produced by you that the damages caused to you was 23 lakhs?
Lordship.
No such evidence was there.
I have given the amount of the gold which the
Request is made for adjournment on behalf of the respondent. The other side has no objection, less in the month of September.
Adjournment request from item number 34 to 38.
Your lordship. Lordship, item number 38, lordship.
Adjourn.
Deeply obvious.
Any other request?
My lord, this matter relates to auction of tea garden, my lord, land, my lord, property. And the auction is going to be held tomorrow, my lord.
Madam, yesterday mention was
Yes,
made.
my lord. But
We asked you to contact the registry, registry. will
we
list-
approved the registry, my lord, and the registry said unless and until there is a court's order, we cannot, my
No,
lord.
court's order can't be given. Registry will take care of that. You move at urgent application, they'll consider it and list the matter in according.
Today, my lord, is unlisted because tomorrow the matter will become
Whatever it may be,
infructuous.
ma'am. Whatever it may be, you go to the registry. We have stopped for the granting permissions in the court. You approach the registry will place it before, on the administrative side, we'll consider.
Yes.
Daily list for orders, item 1.
File an affidavit on 27th of March.
Yeah, lordship,
The respondent has
yes,
filed an affidavit on
That's right,
27th
Your
of March. There is no response to it.
your lordship, I waived my right for a rejoinder because the affidavit I can oppose it on merits and
Okay.
convince
The pleadings
hopefully
are
your
complete.
lordship.
Pleadings are complete. List is
Yes,
complete.
yeah.
Petition for hearing when. We have the contempt petition finally.
I'm sorry, your lordship, I couldn't hear your lordship.
When, this contempt petition for hearing since the pleadings are complete.
Last time, your lordship, it was, I had made the same pleading and your lordship kept it for 8th, but it appeared on the 7th. In fact, I came on 7th and the court was closed. I was under the impression it is for hearing today.
So it is listed in the orders when.
Yeah, I could see that, your lordship. So any date convenient, your lordship.
Again, an affidavit is filed on behalf of the respondent number.
All the.
One, two, and not all, 1, 2, and 4.
Respondent number
1, 2, and
two.
4.
This latest.
Right,
affidavit
this is by 2, my lord. The affidavit is
on
by 2.
27/3/2025, the counsel appearing for the petitioner has submitted that he is not in the requirement of filing any counter to the said affidavit. Pleadings are as such complete. This contempt petition for hearing. Yes, when? In the month of August,
Lordship, can we do it this month?
this month.
Your lordship, I in fact came today for, I don't know, some registry, there was some mix-up. There was some mix.
In the month of August,
In the month of
March of
August.
yes.
Could you fix a date, your lordship?
Please ask the registry.
Just a
fix
minute.
the date on- For your convenient date.
4th, your lordship, 4th or 5th? Fourth or fifth,
Hearing day. Hearing day. Any
5th,
hearing,
your lordship? 5th,
any hearing day, sir.
which is the hearing day?
Tuesday.
Tuesday, your lordship is 5th.
Okay, fifth of August.
Much obliged, your lordship.
Item number 2.
My lord, in pursuant to the order dated 10/3/2025, an affidavit has been filed, my lord. Your lordship, kindly see para 4 of the affidavit, my lord.
Panchayat Raj Department was supposed to. file
Well,
response.
Para
From
4,
from
yes.
the government, my lord, we have filed the affidavit, my lord. We filed the affidavit at page 491.
491.
Para 2, my lord, we have stated, my lord.
My lord, para 4 is relevant, my lord.
Yes, yes.
491.
Para
494, I think.
The relevant is 492, page number 492.
But when you have filed this,
We filed the affidavit on
44.
444.
but it is not on record.
I'll check.
It is not on record. Counsel, Mr. D. Nath, Seniority Government Advocate appearing for the respondent number 1 and 2 has submitted that pursuant to the order passed by this court on 10th of March 2025. And affidavit is already filed on 4/4/2025. However, the said affidavit is not available on record. Registry is directed to ascertain the finding of the affidavit on behalf of the respondent number 1 and 2 on 4/4/2025 and place it on, and if it is so, and if it is filed, place it on record after 2 weeks.
Developed.
We have filed the affidavit on behalf of respondent number 2.
Respondent number 2.
Two. All right.
Item number 3.
Order has been complied with.
Lordship may close the contempt, it has been complied with. Lordship may peruse this.
Let me concept of the parties. I've submitted that pursuant to the order passed by this court on 6/6/2024, passed in writ appeal number 115/2018. The Tejpur University has issued an order dated 1/2/2025. And all the benefits as directed by this court in the judgment dated 6/6/2024 has already been granted. Lanet counsel appearing for the contender has also submitted that the order passed by this court on 6/6/2024 has been complied with. In view of the above, this contempt petition is disposed of, notice is discharged.
Item 4.
May it please your losses, my lord, I have filed one condemnation petition, my lord. 10 days are delay, my lord. Delay may be condemned, my lord. And
Is there any similar appeal?
yes, my lord, writ petition is pending, several writ appeal is pending, my
Any
lord.
number?
It is number 171/2023,
And in those appeals,
pending for
delay-
admission hearing.
delay has been controlled?
Yes.
Yes, yes, most of the cases.
Learned counsel for the parties are in agreement that in identical appeals preferred against the impugned judgment, delay has been controlled and the matter is, and the notices have also been issued to the respective respondents. In view of the above, the IA number so and so is allowed delay of 310 days in filing the connected writ appeal is condoned. Registry is directed to list, register the connected appeal and list for admission after so and so,
Along with 171/2023.
along with so and so number ले लेना उसका. And इसमें कहते हैं ना शुरू में लिखे Mr. So and so put in appearance on behalf of all the respondents, or
I'll be for education, he'll be for finance.
so and so appearing on behalf of all.
I'm.
Obliged.
You are in receipt of that appeal copy?
Yes, ma'am.
Yes,
She has
yes.
given a copy.
Item 5.
My lord, may I pray, my lord, this matter may be taken up after some time, my lord, senior counsel is on legs.
In that case, let it matter come up next Tuesday or Wednesday.
Sir,
We have explained our delay.
Single judges simply
Yes, but
Simply said, give them a suitable treatment.
fitment, for that lordship, we have to constitute the pay commission once more and the anomalies committee. It's a long drawn process under the statute.
Why the pay commission is to be constituted again?
Because the expert, initially we wanted to comply it, lordship. All the experts who are in the department, they are not competent enough to do that exercise.
But if you are not supposed to, if you have not been able to do that, then pass an order that no such fitment is there.
That liberty may be given,
That
lordship.
is already there, sir. That single judge is simply give a
Referred, setting
direction.
aside the earlier fitment table and directed us to draw up a phrase.
So if it is not possible to give any new fitment, pass an order of this effect, sir.
If that observation is given, lordship, then we'll definitely do it. Otherwise, they will come with the contempt case.
What the learned single judges said.
Paragraph page 201.
In view of the
In view of the discussions made,
the matter, the writ petition is still allowed, the impugn communication is set aside, matter is remanded back to the department to examine the issue and pass an appropriate order for revising, amending the fitment table to enable them to get the benefit of so and so as per the notification dated so and so and corresponding order, rejecting their claims, is set aside. This entire exercise would be conducted. If it is not possible,
it is not possible by the persons who are in the department.
once the department take a decision, the revised fitment table issued been unable to get the benefit, revised higher pay scale coroner will be released accountant general with effect from so and so. But if it is not possible that no fitment can be provided, you pass an order.
We in fact consulted the AG office also, got all the persons, but without the pay commission, lordship.
That we have gone through your reply,
Lordship.
that we have gone through your reply. But ultimately, you
This is a highly technical issue, lordship.
Milord, if your lordship would kindly come to page 90, Milord.
1990.
Yes, no, 90. Yes. Now, this is the order which is to be given effect to. What is the difficulty on the part of the state? In exercise of the power, as the lordship got it, Milord, page 90.
Yes.
In exercise of the power conferred by proviso to Article 309 of the Constitution of India.
90.
90, Milord. Of the
90 is
memo,
your reply.
no, of the memo of appeal, Milord.
Memo of appeal, we don't have. The memo of appeal.
একটু একটু আমাকে ইমপ্লিমেন্ট করবো লাগে না? Our right flows from this, Milord. Now, what is the difficulty that I do not understand? In the exercise, as a lordship got it, Milord.
Yes.
In the exercise of the power conferred by proviso to Article 309 of the Constitution of India, the Governor of Assam is pleased to order that following amendments shall be made in the schedule to the Assam Services ROP Rules 2017, published in the extraordinary issue of the Assam Gazette under notification dated so and so. In the pay schedule under the head Panchayat and Rural Development Department, below the subhead so and so, the following existing entries in column 4 and 5 against the post of block development officer shall be substituted as below. Block development officer, revised pay structure, pay band for 30,000 to 1,10,000. So this is to be given effect to.
Let's see. And what do you want to say about this delay confirmation?
The delay, my lord, will kindly see. Normally, we don't object to the delay, but here is a delay of 263 days. My lord, if by filing an affidavit, my lord, where are the materials? Kindly come to their reply, my lord. Additional affidavit.
Yes.
Additional affidavit to come to us, right? My lord will kindly come to page number 59.
Yes.
Running page, my lord. Para 7.
Yes.
That the deponent begs to state that upon various deliberation and examination of the matter, the applicant by letter dated 25/7/2024 requested the learned Advocate General Assam to prefer an appeal in the Honorable High Court against the impugned judgment and order dated passed by the learned single judge in WPC number so and so. In this regard, it is stated that as the matter is related to creation of a new fitment table, which is outside the recommendation of the 7th Pay and Productivity Pay Commission, several meetings were held with Sri Sukumar Deka, the then officer on special duty now retired, in the month of March, April and May 2024 to examine the feasibility of forming new fitment table. Pertinently said, Sukumar Deka had served in the finance PRU for long and was involved in the 7th Pay and Productivity Commission. Further, another meeting was held with R.K. Bujarbudua, retired director budget and consultation of the 7th APPC at his residence on 5 June 24, who has expertise in pay commission and fixation matters. There are no official records of the above mentioned meeting as the concerned officials have already retired from service. The appointment with the consultants were scheduled primarily through telephone. Now, what are these, my lord? Is it acceptable, my lord?
Well, they have taken into
How
consideration
can it
various
not be a
levels.
part of the
If they
record?
have- If they have consulted some of the officers, though retired, what's wrong with that?
No, I'm not saying not wrong in it.
Yeah.
Will it not be a part of the record? Will there be no endorsement in the file that in this connection we had described? But official work, we know how it functions.
That's right, but so far as regarding delays.
And-
We are inclined to condone the delay.
And para 8 also, my lord.
Yes.
Next paragraph, Lordship, the records are there from next paragraph.
Para 8,
Yes.
page 63, that the deponent begs to state that thereafter on the instruction and advice of the learned Advocate General, the engaged counsel of the applicant started preparing the instant appeal. In this regard, it is stated that since matter is complex in nature and the standing counsel for the applicant, that is Finance PRO Department, held several rounds of discussions and deliberations with the officials of PRO Department on several dates in the month of so and so for the purpose. This must be supported by records.
Yeah, delay, we are not going to. So
Anyway, my lord, delay, I leave it to your lordship. But then, my lord, these are all explanations. Improving one's case.
that, we'll hear it on merit. What's the problem? Yes, the matter comes upon for consideration of the IA number so and so. With a prayer to connote the delay of 263 days in filing the instant appeal. Appears that in the IA number so and so, sufficient reasons for condoning the delay has not been offered, and therefore this court why order this 27th of February 2025 is granted time to the counsel for the applicants to file an additional affidavit explaining the delay in filing the connected writ appeal. So pursuant to that, an additional affidavit is filed on behalf of the applicants on 6th of March 2025, explaining the delay in filing the connected writ appeal. The sum and substance of the additional affidavit is this, that since the matter is complex and as per the state government, creation of new fitment tables, which is outside the recommendation of the 7th Pay Commission, 7th Assam Pay and Productivity Pay Commission. Several meetings were held amongst the officials and also amongst the retired official who has expertise in the pay commission and fixation matters. It is contended that on that account, the delay is caused in filing the connected writ appeal. The said additional affidavit is opposed by the respondents, stating that the reasons offered by the state, by the applicants for condoning the delay are not convincing and are also not supported by any documentary evidence, and therefore the same cannot be taken into consideration. having heard the learned counsel for the parties and after going through the condonation application and the additional affidavit filed on behalf of the applicants as well as the counter to the condonation application and the additional affidavit filed on behalf of the respondents. We are of the view that delay of 260 days in filing the connected date appeal is liable to be condoned. Hence, the IA is allowed delay of so and so days in filing the connected date appeal is condoned. The registry is directed to register the connected date appeal and list it.
My lord, since 16, we are not getting, most of them have retired. Some urgency is there, my lord. In month of June, my lord.
In the month of June.
Highly obliged.
Item 7.
May I please your lordship? This IA has been filed for condonation of delay of 198 days, lordship. Lordship, similar matter.
Filed an objection, my lord. Yes, sir.
Similar matter, lordship has already condoned.
Yes, on the 9th, my lord, allowed, my lord.
Delay condone timing and everything.
Only lordship delay is lordship 198 days.
We have our objection may be recorded only, but just.
There are two appeals now.
Yes.
This, in one appeal, there is 198 days delay and another is 415.
415 days. Item number 8, lordship.
Separate orders. Same order.
Item number 8.
Item number 8, my lord, I am appearing for the expedition of.
We have condoned the delay.
Yes, my lord.
Deeply obliged, lordship.
Item number 9.
My lord, IF for delay continuation, let notice goes, my lord.
520 days, 22 days.
My lord, there's a review petition filed, my lord, that review was dismissed.
When?
And this was dismissed, my lord, on 29/1/2025.
What's wrong with the order of the learned singer?
My lord, no,
Not,
my appointment
to
was
a-
set aside.
huh?
My appointment was set aside.
Set aside, you belong to a political party.
No, my lord, I have resigned. That was I annexed. That was not being considered.
So you resigned from the post, not from the party.
That is also by placed later on, my lord. Yes, that was placed, my lord.
When? Later on, after passing of the judgment,
No, my lord.
then,
Before that, my lord.
but you have not produced anything on record.
Yes, my lord. That was filed by on record. It was filed, my lord.
Nahi hai.
Oh, that is in review, my lord. That is in review.
Notice,
Deeply obliged.
6 weeks.
Item 10.
Head constables dismissed from service, taking bribe.
No, my lordship.
No, my lord, it is what the record says.
No, my lordship. As per the charge sheet, my lordship, there is no allegation of taking bribe, my lordship.
So what
There
is the allegation then?
allegation is gross misconduct, my lordship. And
Account of what action?
that is, without checking, I allowed
5 drugs.
in the charge sheet, my lordship, it is 3 drugs, my lordship. I was not allowed to cross-examine, my lordship.
Returnable so and so. IA number ka issue notice of the IA number so and so, returnable 6 weeks, Dusty and new registered daily also. Yes.
For admission, item 12 and 15.
Please allow. The appellant before lordship, my lord, she was promoted, my lord, as a supervisor, Anganwadi supervisor from the post of my lord worker. that promotion will have took place in 2016.
Yes, Mister. You challenge the promotion order after 5 years.
My lord, everything was, nothing was transparent, my lord. Only after getting RTI reply, my lord.
But after 5 years,
My lord, this is a case, lordship kindly see.
and ultimately you have also not been provided this promotion.
No, because I get it. If she gets it, my lord, I have a better right, my lord. We
You
have,
have a better right, but the learned single judge just simply said, again exercise that promotion.
because otherwise I don't meet the cutoff. 71 is the cutoff. I get 69. But if she gets, my lord,
Will you hear this? Will you hear this?
my lord, this is a case, my lord, a pure misrepresentation, my lord. A general candidate misrepresented himself as an OBC candidate, MOBC candidate. It's a fraud on record, my lord.
We'll consider. Learned concept of the appellant has submitted that the promotion the petitioner was granted promotion on the post of supervisor in the month of on
February 6 2016, madam.
6
to 2016.
6 to 2016. However, his promotion was challenged by the private respondent after 5 years by way of filing the writ petition. It is contended that the learned single judge has erred in observing that the delay in challenging the promotion order will not fatal, is not fatal to the challenge made by the private respondent to the promotion order. Full stop. Learned counsel has further submitted that the record of the selection was not available, and in the absence of it, in the absence of it, the finding recorded by the learned single judge to the effect that the promotion of the petitioner, appellant on the post of supervisor is void ab initio, is erroneous. Full stop. Learned counsel appearing for the private respondent has opposed the writ appeal and has argued that the learned single judge has not committed any illegality in passing the impugned order because the promotion of the appellant on the post of supervisor itself was void ab initio. Full stop. Having heard the learned counsel of the parties and after going through the material available on record, we are of the view that matter requires consideration, hence issue notice. The so and so accept notice on behalf of respondent.
Respond number 1, madam.
What 2 and 4?
2 and 4. What about 3?
2, 3, and 4. 2, 3, 4, and 5.
You are appearing for 2, 3, 4, and 5. All the respondents are represented. Mr. So and so is appearing on behalf of respondent number 1, and Mr. So and so is appearing on behalf of the respondent number 2 to 5. Hence, service is complete. Admit clear. Admit clear. Issue notice, admit issue notice. Matter requires consideration. Admit issue notice. Mr. So and so accept notice on behalf of respondent number, and Mr. So and so accept notice on behalf of the respondent number so and so. In the meantime, effect and operation of the impugned order passed by the learned single judge dated so and so in writ petition number so and so shall remain stayed. This in due course.
Item 14.
What should be places? The petitioners four in numbers, your lordship, they are public spirited persons. And they're the resident of lordship village Chaudhary Khat under Kamrup rural district, your lordship. There are altogether 3,000 or more inhabitants the locality. And against the impugn move on the part of the respondent authorities wherein your lordship agricultural land which are in active cultivation till 2024 are transferred to your lordship of cement industry. We have been added as respond number 6.
Transferred by whom?
Transferred by lordship, it was before it was lordship may kindly have a look at page 40, my lord.
Transferred by whom? Who transferred that land?
Individuals, it was by individuals.
Individuals.
Lordship.
Those individuals are party here.
Individuals, we have not made them as party
And
respondent.
any permission is granted for by the court, by the state government to set up a cement industry there?
Lordship,
Any
They-
conversion of the land is there?
no, nothing
Then
is there.
this apprehension, writ petition, how this?
Lordship, I'll satisfy your lordship is against the land policy, my lord.
Whatever it may be, where
My
is the
lord.
land policy? Transfer of the land can't be said to be against the land policy. You are agreeing that if they grant this permission,
My lord.
then it would be violative of the
Lordship, in
land
this
policy.
regard, I'll be relying on one judgment, my lord. May I
No
be allowed?
judgment, ma'am,
Lordship,
but you just still it is premature. They have simply purchased the land in the name of this, whatever the company, and you have approached this court that they may grant a permission, them to convert the land into commercial
Only-
purposes. They may do these things. Where is that?
no, they're, because they are the cement manufacturing unit, your lordship.
Maybe-
My lordship may kindly have a
Until and
look.
unless any permission is granted by the court or any conversion order is there, how this, cause of action arises? to
Lordship,
you?
may I rely on one judgment, my lord?
Yes, sir.
96 5 SCC 647.
Please come.
Yeah. It up from there. Para 11 to 14 onwards, your lordship. Would I say so?
Yes.
Copy it, copy it. Para 11, your lordship. Some of the salient principles of sustainable development as spelled out from Brundtland Report and other international documents are generational equity, use and conservation of natural resources, environmental protection, the precautionary principle, polluter pays principle, obligation to assist and cooperate, eradication of poverty and financial assistance to the developing countries. We are, however, of the view that the precautionary principle and the polluter principles are essential features of sustainable development. The precautionary principle in the context of the multi-municipal laws means environmental measures by the state government and the statutory authorities must anticipate, prevent, and attack the causes of environmental degradation where there are threats of serious and irreversible damage. Lack of scientific certainty should not be used as a reason for postponing measures to prevent environmental degradation. The onus of proof is on the actor or the developer, industrialist to show that his action is environmentally benign. The polluter pays principle has been held to be a sound principle by this court in Indian Council for Environmental Action versus Union of India. The court observed, we are of the opinion that any principle evolved in this behalf should be simple, practical, and suited to the conditions obtaining in this country. The court ruled that once the activity carried on is hazardous or inherently dangerous, the person carrying on such activity is liable to make good loss caused to any other person by his activity, irrespective of the fact whether he took reasonable care while carrying on his activity. The rule is premised upon the very nature of activity carried on. Consequently, the polluting industries are absolutely liable to compensate for the harm caused by them to villagers in the affected area, to the soil and to the underground water, and hence they are bound to take all necessary measures to remove sludge and other pollutant lying in the affected areas. The polluter pays principle as interpreted by this court means that the absolute liability for harm to the environmental extends not only to compensate the victims of pollution, but also the cost of restoring the environmental degradation. Remediation of the damaged environment is part of the process of sustainable development, and as such, the polluter is liable to pay the cost to the individual sufferers as well as the cost of reversible the damaged ecology. Then para 40, Lordship, may kindly have a look at, my lord. In view of the above mentioned constitutional and statutory provisions, we have no hesitation in holding that the precautionary principle and the polluter pays principle are part of the environmental law of the country. Lordship, this respond number 6, Lordship, they are the cement largely manufactured.
Madam, where is the permission? Where is the setting up? Where the industry is set up?
Lordship,
Where
what
is
they have
the,
done, I have
where is the conversion order? Where
24.
the land is converted for commercial purposes or for for setting up a factory from the agriculture, where is that order?
Lordship,
Where
from
is
the
the
very
application?
transmission of land, from conversion land for giving to cement manufacturing unit.
Where is
Itself
that?
infers, my lord, Lordship may kindly have a look, the Jamabandi, my lord, page 40. Lordship may see, my lord.
Ma'am, that's right, but where is the permission from the government to set up the factory?
Lordship, once they establish it, it will become infectious, my lord.
It will be established overnight. First, they will grant the permission, then only it will. It can
Lordship,
be set up.
let them be asked here,
No,
Lordship.
nothing doing, madam.
Lordship
These
may
are the
kindly have a
only,
look, 24 acres of land.
these
We are the
petitions on apprehension, we can't interfere in this.
Lordship, may kindly have a look, my lord. It was converted already by Jamabandi, my lord, by way of Jamabandi, my lord. It was
Converted-
converted to,
Converted to
it was sold out, my lord, to
Sold out,
alternate
that's
cement
all.
industry.
simply transfer of title
Lordship, then
from
when,
Tirupati Builders to cement company.
yes,
This Tirupati Builders was doing what with this land at that in this village?
Lordship,
Certainly,
there
he is
was
not an agriculturist.
it was, Lordship, it was active cultivation, my lord. Till it
Tirupati
was
Builders was indulged in cultivation.
active cultivation, and they obtain instruction, my lord. Because these are the rural areas, your lordship.
It's a premature petition.
Lordship,
until and unless
let
any
them,
permission-
let them take instruction from the
Why
government,
for?
my
Why
lord.
for, madam? You have to satisfy first. Why
Lordship,
we ask them to show?
because they are the highest manufacturer of cement industry,
Maybe-
and it was when it was sold out to them, your
Until and
lordship.
unless any permission is granted or this industry is set up, what is the grievance?
Lordships, as we have come to know, because we are public spirited person, we have no
Madam, we
personal
have,
interest to it,
seen
my lord.
everything. It's only on apprehension and hypothetical that they will grant, then what would happen? This is what all your petition is. If they'll grant a permission, then what would happen? This is what all your petition. is.
Since they are lordship,
This is the petition, ma'am.
that is the petition, but your lordship, since they are the manufacturer, what else they'll do, your lordship? Their business is all over India, my lord. Their only business is
We are aware
manufacturing
of that.
gray
Yeah.
cement, white cement and all, and your lordship is aware of. They are the highly polluted cement in manufacturing.
Until and
unit.
unless, as per this judgment, the state government is required to take all preventive measures. And the industry also is required to take all preventive measures. If they
Lordship,
will not take this, then certainly you have a right to raise a concern. But before that, simply they have purchased the land and you come here, can restrain them from doing this. We don't know what they are
lordship,
doing there.
we have, having come to know about it, lordship, we have filed representation before the authorities concerned.
Yes, better. The
Number of
government
occasions,
will
my lord.
consider
They
those
have not done, my
representation.
lord. That may be observed, my lord, since we have
I
filed our
think they have-
application.
Why should? They have a
Lordship,
duty
it's,
to consider it.
having come to know, lordship, may kindly have a look, my lord. Representation we have filed from 24/6 to 24 onwards,
Yeah,
my
we
lord.
have seen, we have gone through these representations, you have raised a concern, the government will take into consideration that at the
It's
time
been-
of granting any permission, if so.
Lordship,
Ma'am,
since our
it's premature.
representation is pending before the authority is concerned,
Then
They-
why you have filed this petition?
they have not done anything.
Madam, they have granted the permission,
They will,
what they have done?
Not an
ma'am?
application also, my lord.
Just a minute, madam. Where is the application, where is the company has applied for setting up an industry and where they have granted this permission?
lordship, we are just layman. We have gathered this information from the public
The
portal of the
layman-
government of
layman
Assam.
Doesn't mean that if you approach the court, you come with the problem.
Lordship, they will not like, will not be access to the documents.
So they have simply purchased the land. And
That we have come
you
to
have
know,
approached
Jamabandi.
you have approached the government that don't give give them any permission. Till date, there is no order of granting permission
That we are not
by the
aware of,
state
my
government.
lord.
By the state government.
Lordship, we are not aware of because
You are not
they,
aware of then why you approach?
no,
this
your
court?
lordship, we are aware of from the public portal from where we have come to know. The huge numbers of land, huge plot of land has been transferred. From the public portal, we have come to know, your lordship.
It's better, it's a premature petition. Whenever any such action is taken by the state government or the private respondent, then come. And
Then
if
it
a
will be
person
too
who
late,
has
my lord.
already sold the land, you have not made him a party while saying that he can't sold the land, it is against the land policy, you have not made him a party. The person who sold the land to them.
Lordship, we are against the land policy and against the conversion of
Madam,
land
where
from
is the
agricultural to
order-
non-agricultural
Where is the
purpose.
order against the land policy or which of the provision has been violated? Where is that order?
Order, we are not lordship because we are not access to it. We have come to know about the
Madam,
transfer,
your
lordship from the
petition-
public
Your
portal, my lord.
petition, you have simply said that you are apprehending that the government may grant this permission or land conversion permission. That's why only you approach this court and it is premature.
Lordship, at least, my lord, our representation which are pending before the authorities, that may be observed, my lord, in the order.
Then consider it.
Lordship, because it will 3,000 persons will be affected, 3,000 or more inhabitants.
Mandamus shall not be issued restraining the respondent authorities from granting any statutory permission for setting up a cement manufacturing packaging industry. Still, you are admitting no such permission is granted. As per your prayer itself. Declare a moratorium on reclassification and transfer of agricultural land for non-agriculture purposes. Blanket order. How these reliefs can be granted, ma'am? Directing the respondent department to cause an inquiry to review all the cases or pending applications submitted by the respondent company for a classification. Where is that application?
That application, we have not,
So, ma'am,
lordship,
this
and
is
I read,
altogether premature petition.
lordship, at
Then-
least, my lord, since our representations are pending before the authorities, let me be observed, my lord, in accordance with the.
We are not going to
Pass-
observe anything. Because this PIL petition is filed.
Lordship, we may be allowed to withdraw then, my lord.
That's fine, but that's better. After attempting to argue the matter for quite some time, and when this court has expressed its views that the PIL petition is premature, learned counsel for the petitioner fails. But learned counsel for the petitioner on instruction has submitted, he wants to withdraw this PIL petition, dismissed as withdrawn.
Item 15.
A writ appeal against the order dated 18/3/2024 passed in WPC 6609. Petitioners, my lord, have been serving the BRO grave for the for the around 30 years.
Supreme Court has already ruled, sir.
My lord, that's what the Supreme Court, that is what I was trying to impress, my lord. If lordship has a look at the orders which were referred to, the judgment of 2019, just try to refer to it, my lord, once that it was not correctly appreciated in the manner. By the learned single judgment. What had happened in the 2019 case, lordship will find at para 7. Para 7, the Honorable High Court had directed at para 7, page 2,
Yes.
the subclause 24.
Yeah.
A, Union of India is directed to frame a scheme within a period of 3 months. 2, the B, Union of India is directed to pay the members of the respondents the minimum of the pay scale. C, Union of India is directed to implement all labor laws. D, communications with students who are declared ultra virus. E, Union of India is directed to give temporary status. Now the Honorable Supreme Court at para 14 says,
This
I am sorry, para
this
16.
ABCD is the direction of the
High Court, Honorable High Court Division Bench, and that at para 16, what the Honorable Supreme Court said was,
Yeah.
the High Court failed to see that it is not the function of the courts to frame any scheme, but it is the sole prerogative of the government to do it. All that the High Court in exercise of extraordinary power under 226 can do is direct the government to consider for framing an appropriate scheme having regard to the facts and circumstances of any case, which this court did in the case of Union of India Supra, but not beyond it. It is only in exceptional case where the court considers it proper to issue appropriate mandatory action, it may do so, but not otherwise. It is not in dispute that the Union of India has now framed a welfare scheme for all casual workers. Then Lordship would have para 20. In the light of the foregoing discussion, we are unable to agree with the reasoning and the conclusion arrived at by the High Court in the impugned order. As a consequence, appeal succeeds. So the mandatory directions that was given were set aside by the Honorable Supreme Court. Our case
They have
was
simply said it is for the state government. Now the state
My-
government has come with this, since it's not a seasonal, it's a work.
that is
seasonal
what I
work.
was trying to.
We are not engaging them on permanent basis and therefore no regularization can be made.
That is what an
And in
admitted position.
Another judgment of the Honorable Supreme Court in Border Road Organization on this All India Trade Trade Union Congress.
That is what I just read out, my lord. This is the judgment we are reading out. This is the judgment. But what I was
in
trying to.
relation to the Border Road Organization.
Yes, yes. Now, my lord, what I was trying to impress, your lordship, there are two types of work in the BRO. Admitted position. One is the seasonal intermittent work where constructions are carried out at different sites. The persons who are now engaged in the Eastern-based workshop, admitted by them in the affidavit in opposition, it is a permanent establishment. It doesn't move. It stays where it is. It carries out the permanent nature of work where all the trucks, machineries, everything is brought in for repairs and maintenance. Now, these people being engaged for over 30 to 40 years. As of date, it is more than 40 years that they have been constantly been engaged. There is no change in their engagement. That one person goes out 3 months later, someone comes in. No. Matter of record, every 6 months, 1 day break for the last 40 years. The same persons are working there. The establishment admittedly is a permanent establishment. There was a direction to consider framing a scheme. Only reason it has been rejected is all projects of the BRO are not permanent, they are mostly seasonal. But those establishments which are permanent, where people have been engaged, these very members have been engaged for over 40 years, can they still be called seasonal or intermittent? Would it govern the entire, all the casual paid workers, or was it upon the respondent government to find out whether there is a permanent establishment and whether same people have served for the last 40 years?
Yes.
That is what I was trying to impress. This judgment was only to the extent that there can be no mandamus to do something. You pay like this, you give like this. That was set aside. There is no dispute on that. But the framing of the scheme, Lordship will find the earlier cases.
The government has already framed the scheme and they said, "Okay, we can't do that."
My lord,
That is not that the government. has
that is
already framed the scheme. And they
a-
found that these set of employees can't be regularized.
But that cannot be regularized. That is what the only ground given is it is seasonal and intermittent. Our only ground is being a permanent establishment, having engaged us for 40 years and above. Can it still be seasonal and intermittent with 1 day break every year?
That in Vartak, this labor union,
Yes, madam.
there was the same,
We are the same persons.
same person.
Yes.
In your case, this court has granted direction to regularize your services that the Supreme Court has annulled.
And has directed them to frame a scheme.
They have already come with this, we can't regularize their services for these reasons.
The
because-
only reason given is it is seasonal and intermittent.
No, another is that there is no, this, read here.
Madam. The letter, if Lordship has, madam, that is the only reason given. There is no other. Lordship may have page 96, madam. The reason given is given in the letter. They would not better their case in the.
It does not classify its casual paid laborers basing on the nature of their employment. There is no such financial aid of this effect.
No, but when an establishment is permanent, when the people are there being employed permanently with a day's break, can they still say that we will not classify it? Well, engaging someone for constructing a road for 2
There
months.
is no regular budget provision for their wages in the annual budget of the organization, and the wage are paid or out of the funds earmarked for the works which they were so employed depending
is-
upon the workload as being provided by the various department by whom the work is so entrusted.
The grave vehicle, if it breaks down, it will not depend on the project money to be repaired. These people are being paid monthly for 6 months, a day's break, again the next 6 months they get a pay.
Yes,
If lordship has page 96 for a moment, my lord,
yes,
why they rejected it?
yes.
Lordship will have para 6.
Yes,
The duties of casual paid laborers and the Group C employees, pioneers existing in the department are largely varying in its nature, and that the casual employed paid members are not engaged in against any regular vacancies, and there is no post of casual labor in the BRO. The Supreme Court has held that posts would not fall from heaven. If they need to regularize, it has to come. Para 7. That the nature of work undertaken by BRO, an integral part of the army, is intermittent and seasonal. There is not enough work to keep the labor engaged throughout the year. That is why whenever the situation arises, this casual labor is hired on daily basis, daily wages basis, and not on a regular basis. Now, this is true for those work which are intermittent and seasonal and are project based. Eastern based workshop, lordship will find in their affidavit in opposition. I'll just take one line. Lordship may like to have page 116, my lord. I'm sorry, 115. 116, para 10.
yes.
1, 2, 3, 4. 7th line from the bottom, my lord. It starts with the words be termed. Lordship finds. From the bottom, it is the 7th line I'm trying to read. Starts with the word be termed.
Page 115,
116, my lord.
116.
Para 10.
The
From the
casual
bottom,
paid laborers are employed for the job intermittent temporary based on the workload, hence cannot be termed as so and so in this
Continuous-
regard.
Next, in this regard, it is further submitted that although the Eastern Bake Workshop is a permanent establishment,
Then
their
magistrate-
budget is directly reciprocally varied upon the dependent projects to cater the needs of the technical and machinery support. Now, persons who are working in a permanent establishment over the past 40 years, the same persons, had it been engagement of different persons at different point of time in the year, based on the project or the workload, it would have been a different issue. What we are trying to impress is 40 years with a day's break on a permanent establishment, can we still be said to be seasonal and intermittent in nature? My lord? That is what we were trying to impress.
Yes, Mr. Chaudhary.
So far as Lordship, my friend's submission is concerned, Eastern based workshop, it's an office, it's an establishment. There's no dispute about that. Now, so far as the services of the petitioners are concerned, whether there being an office and the services required can be equated. Now, here is a case. Lordship knows the BRO is engaged in the border roads developments and all those things. There is a central workshop. At times, when the works are on basically in the winter season, Lordship, when there is no rain. Now, when the works are on, at that point of time, Lordship, there will be more casualties to the vehicles. Only then when is the time when we will need more people there. And it cannot be a ground that since the office is there, we have to be regularized. Now, their prayer in the repetition, if your Lordship will come to the repetition, in page 46, their prayer was substantially for a regularization.
It was setting aside of the intermittent part,
Yes,
that it is intermittent and seasonal.
if I may take your Lordship to page 46.
Yes,
In the premises aforesaid, it is most humbly prayed that this honorable court would be pleased to issue notice to the respondent so and so as to why the honorable court should not issue a writ, thereby quashing the endorsement dated 7/9/12 issued by the respondent number 3, and further direct the respondents to initiate appropriate steps within the stipulated time frame to consider the members of the petitioner union for regularization of their services. This is the substantive prayer.
yes,
And as it is, Lordship, the question of regularization, as has been pointed out, Lordship, went up to the Supreme Court. And when the authority could not frame a policy for regularization, a contempt was there, and the Supreme Court said no. There is no contempt because 90,000 people approximately. It's not possible, Lordship. Yes.
The Supreme Court, while closing the contempt petition, said that the endorsement can be challenged in the appropriate forum of law. That is one part, while closing the contempt. Secondly, my lord, their entire standard 90,000 people have to be accommodated for regularization was never the stand of the union. The union stand is only where there is a permanent establishment and where the same people have been engaged throughout the year, not on the basis of seasonal work or anything. Throughout the year, records will show throughout the year they have been engaged for the last 40 years as of today, whether they were entitled for consideration of a frame or of a scheme where they could be considered for regularization. That is all.
Close for orders.
Right.
Item 16.
My lord, while disposing the earlier round of writ appeal, my lord, the lordship was pleased to give the liberty at page number 396, my lord. That is how we are before your lordship.
396.
At page 397. Because the recruitment process started before new pension policy was introduced, but the appointments were made subsequently. At page 397. Lord, this third subpara at page 397. In view of the above development, has the lordship got it, Miller? In view of the above development, we are of the view that once the state government has decided to consider the demand of the employee, who were though appointed after 2005.
It is
Very
in, it is in these, against this orders only?
No, my lord, your lordship gave us liberty, then the state government again decided against us.
No. This 188/2023 is the writ appeal against which order?
Writ appeal against the order passed by the learned single judge, my lord, there was a good order too. 263, my lord. And the operative portion is at 371. Please come to page 371, my lord. Roman 3.
No, this.
The order of the learned single.
Earlier writ appeal
Yes,
was against.
this order at page 371, my lord,
Was
Roman 3.
against the very same order.
Yes,
But then how you can challenge this?
Your lordship-
of writ appeal, sir?
that's why your lordship gave us the liberty, my lord.
Liberty to
No.
approach the court again by filing fresh writ appeals.
Ah,
Writ appeal.
yes, my lord.
Can-
397, my lord. It is made clear that if the appellants fail to get any favorable decision from the state government, they are free to approach this court again by filing fresh writ appeals.
Seems wrong, writ petitions are much. Yes, then
That is how, my lord. Now, the order of the learned single judge is at page 371. We approached the earlier writ appeal because of this, Roman 3. Many other aspects were also dealt with. We are agreed by this portion.
371.
371, para Roman 3, my lord. The teachers coming within the fold.
Just a minute.
Yes.
Yeah.
Yes. The teachers coming within the fold of teachers appointed under Operation Blackboard, and more particularly those teachers who were appointed pursuant to creation of 7066 post on 8/3/21 would not be entitled to pension in terms of rule of 1969, as well as shall not be entitled to join the fund in terms of the General Provident Fund, Assam Service Rule 37. They shall be governed by the new pension scheme applicable to government, state government employees of corresponding rank.
This is the conclusion.
Against this order, we approached
This is
the
this is
earlier
the
writ appeal.
conclusion. This is the
In the
conclusion.
meantime, there was a development, my lord. The
In the
chief
meantime,
minister,
there's government build, this meeting in
Yes.
between the chief minister and they said they will consider.
yes,
And now they have rejected
again rejected.
that because since now the government has not taken any decision on that and since the new policy is, central government is there, therefore, no relief can be granted. That is what
Yes.
but here you come to this, para number 75 of the judgment where your cases were considered by the learned single judge. What's wrong in that?
No, that is why we filed the appeal, earlier appeal.
Now argue it on this. What's wrong in this the orders?
Para number,
75 to 101. Your cases were considered.
yes. It's, no, my lord, operative portion is this, at page 371, which I read.
But
Now, my case is very simple. Our case is otherwise, if your lordship should kindly come to the meeting and the Government of India Minister of Minutes is at page number 376. It was because of this lordship said that let government
just
decide.
a minute.
Page 376.
Just a minute.
আমার যদি রিপিটিশন ফাইল করবো লাগে আমি রিপিটিশন ফাইল করি তখন উদ্যোগ করি হুম 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 এই 197 এর অর্ডার পেজ ইহাতক দিলে না হুম পেজ 197 হুম সব বেনিফিট দিলে 10% এপিডিও তো দিলে হুম হুম
Yes.
Yes. My lord will kindly come to page number 376. Minutes of the meeting held on 15/3/24 in the conference hall of the Honorable Chief Minister with Hodo Assam Karmachari Parishad and the chairmanship of the Honorable Chief Minister. Now please come to one. Government of Assam will consider extending the benefit of old pension scheme to those employees who joined the government service after January 2005, but recruitment process for for the concerned post was started prior to January 2005 in line with the recent OM issued by the central government. Now, central government OM is at the next page, my lord. Page 378,
Yes.
13/7/2023. Please come to para 3.
Yes.
The matter has been examined in consultation with the Department of Expenditure, and it has been decided that all India service officers who have been appointed against the post vacancy, which was advertised notified for regular recruitment prior to the date of notification of new pension scheme, that is 22/12/2003, and who are covered under the NPS on joining service on or after 1/1/2004, may be granted one-time option to be covered under the provisions of old pension scheme. In line with this decision, my lord, that Chief Minister, Honorable Chief Minister made the decision. Now, because of this, your lordship's order at page number, my lord, 396, it starts. If your lordship will kindly come to page 397, oh, sorry, 396. The first subpara towards the bottom of the page. These writ appeals are filed by appellants being aggrieved with the order dated 31/3/2003 in WPC number so-and-so and other identical connected writ petitions. The learned single judge has refused to grant relief to the writ appellant to issue a direction to the state government to grant them pension as per the Assam Services Pension Rule 69, that is the old pension. These appeals relate to 706 of the OBB teachers. It is informed that a meeting took place between Honorable Chief Minister of Assam with the Assam Karmachari Parishad on so-and-so. It is decided that government will consider extending the benefit of old pension scheme to those employees who joined the government services after January 2005, but the recruitment process of the concerned post was started prior to January 2005. In the line with the office memorandum issued by the central government, learned counsel for the appellant has submitted all that the appellants were appointed in the year 2002 and 2001, and therefore their case comes within the ambit of the aforesaid decision of the meeting. It is further submitted that the issue regarding extending the benefit of old pension scheme to those employees who joined government service after 2005, wherein the recruitment process was started prior to 2005, is pending with the administrative department. In view of the above development, we are of the view that once the state government has decided to consider the demand of the employees who were though appointed after 2005, wherein recruitment process of the concerned post was started prior to January 2000, despite the order passed by the learned single judge, it would be appropriate to dispose of these appeals, awaiting the decision of the state government on this issue. It is made clear that if the appellants fail to get any favorable decision from the state government, they are free to approach this court again by filing this writ appeal. So your lordship just considered everything, my lord, the learned single judge's order. Now, if your lordship feels that no, this writ appeal was inadvertently crept in, my lord, we can go to the single judge. But the fact of the matter is,
We'll consider it.
yes.
Once we have given-
Now, my lord, our case is very simple. The government's own professed, promise that they will consider, they have not done it. Therefore, your lordship gave us liberty swear before your lordship. Our case is nothing but in terms of the DOPT OM issued by the government of India. In respect of all India services, when new pension scheme was introduced, a one-time option was given. And my lord, other similarly placed persons were appointed in 2010. Now they are getting pension under the old pension scheme. And my lord, most importantly, my lord, there was an earlier order of a cognate learned single judge. If your lordship would kindly come to page 195, my lord, where in an earlier round of litigation, this observation was made by the single judge and which has also attained finality. Page 195, para 56.
Yes.
In a legal parlance, a decision means a determination by authorities by taking into account all such relevant parameters that are required to be taken into consideration to arrive at a definite conclusion. Accordingly, it is deemed appropriate that interest of the justice will be satisfied if the highest authority in the finance department of Government of Assam, which is stated to be the additional chief secretary in the finance department, takes a wholesome decision on the aforesaid factor as to whether the class of employee who had a legal right to be appointed or regularized prior to 1/2/2005. But because of certain other intervening circumstances, such right of regularization was not effected prior to such date are to be covered by Assam Services Pension Rule 69 or by new contributory pension scheme. In arriving at the decision, the authority shall state the detailed relevant parameters that they would take into consideration and the reasons thereof as to why authority arrives at the decision that it would take. In terms of the above, as regards the claim of salary in the scale of pay or for regularization from the date of initial appointment, the same stands rejected. And as regards the issue as to whether petitioners would be covered by Assam Services Pension Rule or new pension scheme, the same is disposed of in terms indicated above. So, my lord, regarding regular salary and all, prospectively it was given. And regarding pension, my lord, the matter was left open. So these issues are open, my lord. Yes. And my lord, if your lordship would kindly permit me to place para 55 also at page 195. But in between, another class of employees are also in existence like those of the present petitioner. This class of employee had a legal right to be appointed or to be regularized prior to 1/2/2005 and had the same legal right to be appointed or regularized been honored by the state respondent authorities, they would have otherwise come within the class of the people who were appointed or regularized prior to 2001 to 2005, and as such would have been governed by Assam Services Pension Rule. But in spite of having such legal right, the respondent authorities had neither appointed nor regularized them prior to 1/2/25. And on the other hand, they were regularized subsequently. Neither the Assam Service Pension Rule nor the new defined pension contribution scheme makes any provision for such category of employee. Although occasionally we have the instruction from appropriate authority in the finance department that such category of employee will be covered by the new pension scheme, but such instruction are more of view expressed by the concerned officials rather than a decision itself by the finance department in the government of Assam. This was also an aspect which was taken note of. Therefore, my humble submission is, my lord, similarly placed OBB teachers who were appointed in 2010, after they are getting, my lord. So in that view of the matter, my humble submission is, my lord, our case also should be considered. Yes, and the reason given in the impugn order, if a lordship would kindly come to page number 401, my lord. Yes. Please come to page 401. Yes. As per the minutes of the meeting which took place between the Honorable Chief Minister and Assam Karmachari Parishad on 15/3/2024, it was decided that the government of Assam will consider extending benefit of whole pension scheme to those employees who joined the government of service after January 2005, but the recruitment process of the concerned post was started prior to January 2005, in line with the office memorandum issued by the central government. It may be mentioned here that for the process of recruitment started from publishing advertisement against any vacant post till joining of the selected employees, the state government takes longer period than the government of India. The central government follows the stipulated time limit for the same. So this central government notification for one-time option will not be applicable for the state government employees in this ground. As of now, state government has not taken any policy decision on this matter. In the meantime, Government of India had announced unified pension scheme in 2024, but the notification along with guidelines are yet to be issued. State government will have a considered view after receipt of the notification and guideline of the unified pension scheme once it is issued by the government order. Expressly, our claim has not been rejected also. At the same time, it has not been considered also. But my only humble submission is, my lord, in your lordship's earlier order, the direction that was issued to the government to consider was despite the learned single judge's order. In a sense, my lord, your lordships had taken note. Please come to page 397. This is very important in my humble submission. that in view of the above development, we are of the view that once the state government has decided to consider the demand of the employees who had, though appointed after 2005, wherein the recruitment process of the concerned post was started prior to January 2000, despite the order passed by the learned single judge, it would be approved. This line, Miller. So your lordship said despite the order passed by the learned. So therefore, the observation which are there in the order of the learned single judge, that will not come in the way. Otherwise, it is open for the state government to consider it. But for that word that can file a fresh petition, we would have filed a, normally we will file a writ petition.
Yes,
Thank you.
Mr.
Yes. May I please, your lordship? I am representing the finance department, my lord, which have issued the order at page 401, my lord, which lordship has seen. My lord, I understand, my lord, that this writ appeal has been filed in pursuance of my lord's earlier order, my lord, in a my lord series of matters. My lord, this judgment and order, my lord, dated 31/3/2023, my lord, that pertains to, my lord, whether the writ petitioners therein, my lord, were to be entitled under the old pension or the new pension. My lord, in that, my lord, common judgment and order, various categories of teachers were considered. One of such categories is, my lord, the OBB, Operation Blackboard. Now, there we had argued, my lord, before the Honorable Single Judge, that since it was a post under the scheme, in terms of the settled position of law pronounced by the apex court, that past services cannot be counted because it is not a regular service. Nonetheless, my lord, the matter stands on that position and these writ appeals came to be filed. Now, my lord, your lordship's order, which my lord figures at page 396, on that day, my lord, the category of teachers who fall under the OBB scheme, they came to know about this development, my lord, that a meeting was, my lord, convened between the Honorable CM, my lord, and the Kodorokam Karmasari Poripad, that is, my lord, the employees body, my lord, union. Now, a decision was therein taken, my lord, that it will be considered. Nonetheless, my lord, no promise has, my lord, fallen, my lord, from the state government. And now it was only in the matter of consideration. Therefore, my lord, the finance department has initiated the exercise, my lord. And this order, which lordship finds at page 401, came to be issued. Now, my lord, at present, I have the instructions, my lord. Now, some fresh writ petitions are also coming up, my lord, before the Honorable Single Judges of this Honorable Court, where, my lord, taking a cue of lordship's order, my lord, these writ petitions are being filed. There we have filed affidavits, my lord, whereby, my lord, we have also annexed, my lord, some particulars to show, my lord, that the finance department has issued letters to all the respective administrative departments, not only the education departments, there are other respective, calling for the data as to, my lord, what are the number of employees who were appointed, my lord, post 1/2/2005, because 1/2/2005, my lord, is the cutoff date. Now, and who were, my lord, recruited at an earlier point of time, but who were not given the benefit of old pension scheme. Now, the matter stands, my lord, in that state of affairs.
That's altogether different thing. Despite the order of the learned single judge, if you are supposed to give, grant them. If you don't give them.
Therefore,
We are here to consider this validity of the judgment of the past by the learned single judge.
Yes, so
whether it is
therefore,
correct or not.
yes, therefore, my lord, my respectful submission today will be, my lord, since my lord, I am today not prepared and my lord, these bunch of writ appeals are also pending before this honorable court, my lord. Today also, my lord, in item.
Petitions are all together.
My lord, let this matter be also be taken up, my lord, along with those, my lord, writ appeals, my lord.
We already asked Mr. What do you want to say?
So, my lord, then I will have to, my lord, resist this writ appeal, my lord, on merit, my lord. I need some time, my lord. Kindly accommodate.
We'll dispose it off. That's all. Yes, what do you want to say?
After SPS or OPSC with the
Finance department. Okay.
otherwise.
The matter is heard finally at that motion stage. Order is up.
My lord, can I just indicate one thing, my lord? Now, basically, my lord, our writ appeal is structured on the basis that despite some sort of an understanding which was arrived at, now they are reneging it from it. As such, we have not made our submissions on the merit of the writ appeal, my lord. As such, we are not challenged because that's why I pointed out your lordship, despite that single judge's order, this matter should be considered.
In that order, we have simply said, okay, your prayer for consideration for granting you the old pension scheme was negated by the learned single judge. And you said, okay, since there is a government that is taking into consideration, we have simply said, yeah, despite the order passed by the learned single judge, if they are doing so, it's okay.
Therefore, my lord, what I was trying to submit for lordship's kind consideration, my lord, on merit, my lord, if your lordship give us one opportunity to assign the single judge's order.
Next week?
Yes.
Next week.
Next Wednesday, my
merits,
lord.
hear it on merits.
Yes, next Wednesday, my lord. Oh, I'm sorry, my lord, Thursday, my lord, not Wednesday. Wednesday, I have got Thursday.
Yes, Thursday. Thursday is the hearing this.
Or Friday, my lord.
Friday.
Friday.
Friday. Thursday is the hearing day. Yes,
I'm obliged.
Item 18.
Diplomat.
yes. Yes. What is the spelling?
Item 18.
Wait, please, your lordship.
Yes.
What had happened, there is a particular guest house of Indian Oil Corporation.
Anybody is appearing for the.
No, my lord.
Issue notice returnable 2 weeks के बाद की date है ना 10 and sorry.
Item 19.
Similar matter, man.
As well as the registered date, 2 weeks. Did you say notice here? Yes.
I have indicated the, that order, impugning order date, in the.
The order is same, the date.
Malat, same issue is same, Malat.
The date of impugned order is same.
Malat, I indicated date of impugning order is 6/4/2023 in the top of the Malat.
Passed in
In OA 27 or 2021, Malat.
27. OA number 22 is the 27 आएगा. Order is the 6/4/2023 is the same order. और connect with उसका number भी जोड़ते हैं.
Earlier.
Item 20.
May I please, Your Honor?
So why you implemented the Guwahati High Court and the sketch?
It is in a sense a pro forma because the High Court has also written a letter.
That's in,
That is, I think, irrelevant so far as
then sir, this.
it is only because of that letter we had thought that we should also.
This repetition,
Otherwise, your lordship has, this court has nothing to do with this matter.
that's why only we are saying because it is listed before the division bench because you have made the Guwahati High Court as party only. Otherwise, it would be, have to be listed before the learned single judge.
Oh, I see.
Any High Court party. That is what.
Oh, I see. Actually, Milord, your lordship has seen that High Court order. It is
they have
of no
simply quoted that 14, rule 14.
14, which is not applicable at all.
That is not applicable, that is the case.
So it is of no
It's
use.
appearing for the central government. Maybe this 2, 3 and 4. 2, 3, 4, 5. How can you ask for a recovery of this money? Because at the time when you sanction the pension, you are aware of that he is getting pension as a High Court judge also. SBI is not seeking, as per the direction of the central, this pension accounting office, SBI is seeking recovery. How can you do that? And that is also without giving any opportunity.
All of a sudden, after 20 years, Milord. এখন কোন নব পেজ এটা ছিল one month.
We'll pass it over for some time. Because we just want to clarify the court that despite if the High Court is not a party, then also it is to be listed before the division bench or since it's a matter of some pension matter. It is to be listed before the division bench or single bench, then we'll consider. We'll get a clarification from the registry.
Yes, I am not assuming that.
Item 21.
May it please your lordship. The lordship will turn to a division bench order of 9/12/24. Yes. This is a matter relating to probity in public office. Malad, we have, Malad, before I start my submission, I'd like to make it, Malad, I'd like to make one submission that I have no grievance against the promotion. My prayer is not there. What I want in terms of the Supreme Court's order on probity in public transparency, I wanted inquiry which was pending for the past 8 years. Lordship, I'll read the order. I beg your lordship, I'm having problem with my voice. Heard, the order is on 9/12/2024. Heard such and such. Taking note of the issues reflected in the order of 22/5/2024, the court is inclined to direct the learned.
That inquiry is going on.
Yes, well, if the inquiry is going on, I know my limitations. Let them give an affidavit. I have no.
What affidavit?
Well, to the effect, there is an order of the division bench
Sir,
that what is the
in
status?
essence, your petition, we have gone through your petition and we made your observation earlier also that essentially this writ petition you have filed in the PIL, being agreed with the promotion of the petitioner on the appointment of the petitioner.
No,
on
my
the post of chief engineer. This is what we have observed.
Well, your lordship has taken the division bench's view, but your lordship's view was taken on 9/12/2024 by the similar concurrent jurisdiction division bench, stating that we would like to know the status of the inquiry.
that-
So I leave it to your lordship.
That they have already submitted.
Yes.
The inquiry is going on.
Yes. Then your lordship can dispose it.
With reference to the subjects, I am directed to
Yes,
inform
yes.
you that the regular inquiry initiated against the so and so. Shri Devajit Das and then.
His name is-
Engineer, the final inquiry of the regular was sent to the government for closure of the inquiry. However, the government has asked the director of inquiry to rewrite order dated according further inquiry in the matter. Accordingly, follow-up action are being taken in the light of the government instruction and inquiry will be submitted soon.
Yes, then that's my prayer. So your lordship may close with this observation,
This
because I know my limitations.
PL petition is filed by the petitioner.
Prayer is a page. Lordship, my prayer is at page 30.
The following prayers. Page number 30, prayers. Seeking the following prayers. Full stop. This court. White order dated
9/12/20.
22nd of May 2024. Has expressed its prima facie opinion that the writ petition, that this writ petition in the form of PIL is not maintainable. Because essentially, the petitioners have raised grievance with regard to the promotion of the respondent number 12 on the post of chief engineer PWD. Full stop. On that date, learned counsel for the petitioner has claimed that the petitioners are not agreed by the promotion of the respondent number 12 on the post of chief engineer. However, this court has observed that from the averment made in the writ petition, it appears that essentially the grievance raised in this PIL is regarding promotion to the respondent number 12 on the post of chief engineer. The court has granted time to the counsel for the petitioners to satisfy this court on the maintainability of the PIL. Full stop. On 9/12/2024, a coordinate bench of this court directed the additional senior government advocate to inform the court about the status of regular inquiry pending against the respondent number 12 in respect of certain charges. Full stop. Again on 7/2/2025, this court granted opportunity to the counsel for the petitioner. This court granted last opportunity to the counsel for the petitioner to convince it regarding the maintainability of the PIL petition, which while observing that in the prima facie opinion of the court, the grievance raised by the petitioners in this writ petition is in this PIL petition essentially with regard to the promotion of the respondent number 12 on the post of Chief Engineer PWD. Full stop. It appears that the additional government advocate Assam has produced a letter dated 22/1/2025. Produced the communication करते ना dated 22/1/2025 issued by the Office of the Directorate of Vigilance and Anti-Corruption Assam, wherein it is mentioned that the regular inquiry pending against the respondent number 12, that in the regular inquiry initiated against the respondent number 12, a final inquiry report was sent to the government for closure of the inquiry. However, the government has asked the directorate for further inquiry to the said further inquiry into the matter, and accordingly the follow-up action are being taken in the light of the government instructions, and the inquiry report will be submitted soon. Full stop. At this stage, the net counsel for the petitioner has submitted that since the regular inquiry is pending against the is going on against the respondent number 12, as per the communication issued by the Director of Vigilance and Anti-Corruption Assam, is satisfied and is not pursuing this PIL petition. Stop. In such circumstances, this PIL petition is disposed of.
Obliged.
Mr. Goswami.
Pass over, sorry,
Mr. Goswami,
item 20.
sir, we have confirmed it is listed only because the High Court is party.
I see.
Now, if you wish, then while deleting the name of the High Court, we
Yes.
can order it to be listed before the learned single judge.
Your lordship, because it is of no consequence so far High Court is concerned.
High Court and the cat
Nothing to
also,
do it.
and the cat also. This
Only thing that because of that letter, we thought that High Court should be also. That was not even sought
there
for.
was no requirement on the part of the High
Correct,
Court,
correct.
write such letter,
Correct.
but if they have done it,
Absolutely.
this writ petition is placed before the division bench because the respondent number 7 and 8 are being made party. But because the Registrar General, the Registrar General of this court and the Registrar of the Central Administrative Tribunal, Guwahati bench, are made party as respondent number 7 and 8 in this writ petition. Full stop. Having gone through the writ petition, we are of the view that since since the petitioner has not claimed any relief against the Guwahati High Court and the Central Administrative Tribunal, Guwahati bench, they are neither necessary, they are not necessary party
that.
for adjudication of the issue raised in this writ petition.
Who did it to?
Full stop. Mr. P.K. Goswami, learned counsel, learned senior counsel has also frankly submitted that as no relief has been claimed against the respondent, against the Guwahati High Court as well as the Central Administrative Tribunal Guwahati bench. They are not necessary party in the writ petition. Stop. In such circumstances, we deem it appropriate to direct the registry.
That may be a proper party, Lord, even if not a necessary, because they may, your lordship may require some papers or something. They should be there.
देखिए, इसको काट। This writ petition is filed by the petitioner. Being agreed with the action of the respondent there is that order, recovery order,
Page 48 and 55, Milo.
48.
Yes. 28/1/2025. And at page 55, repeating the same thing.
Yes. Being agreed with the order dated 28/1/2025
And 12/2/25.
issued by the State Bank of India. Guwahati, State Bank of, Assistant General Manager of
PPC.
State Bank of India of Guwahati requesting the petitioner to deposit the amount of rupees 57,30,226 for refunding amount of rupees so and so, which as per the Central Pension Payment Center has wrongly been, paid in excess to the petitioner. The petitioner is also aggrieved by the, which order?
12/2, page 55, Milo, same.
Page
12, page 55.
55.
12/2/25. But tell us a repetition of the earlier reminder.
So we can, being agreed with the
Two parts, Milo.
21/2025 and 12/2/2025 orders issued by the State Bank of India. Assistant Manager, State Bank of India, Guwahati. Requesting, directing the petitioner to refund the amount of rupees so and so, so and so, which has wrongly been, paid to him.
There are two parts, Willard. One is
Because the
that
same is
Mm.
being treated as, because the same is, being termed as excess payment, excess pension payment by the pension department. Full stop. The concept of the petitioner has argued that before directing the petitioner to refund the aforesaid amount, no opportunity was hearing is granted to the petitioner and the respondents number and the respondents particularly the pension department as well as the State Bank of India has unilaterally adjust the amount of rupees 57,30,226 as excess payment. Full stop. And it counsel has further submitted that the services rendered by the petitioner as judge of the Guwahati High Court and the vice chairman of the Central Administrative Tribunal Guwahati Bench are two independent engagements and for which the petitioner is entitled for separate pensions. Full stop.
And next page 56, very interesting, Willard. After stopping the pension and also asking us to repay, there is this letter at 56, they are asking whether the person concerned petitioner is eligible or not. Kindly see the
Yeah, they
letter.
are asking for that.
Page 56, last paragraph, Miller.
Yes.
In view of the above, we request you to please advise whether Sri Chaudhary is eligible or for dual pension against so and whether the maximum eligibility of basic pension to High Court judges is so per month at present. So they are demanding stopping the and also demanding refund
Issue
and
notice.
still not clear.
Issue notice. Mr. So and so accept notice on behalf of, yes.
I mean, respondent number 7, my.
No, first, who is appearing for the respondent number 1 to? Your, Mr. Chakravarti put in appearance on behalf of the respondent number 1, who is appearing for respondent number 2 and 3? Huh? Okay, Mr. PJ Mehta put in appearance on behalf of the respondent number 7. Let. Respondent number? Mr. So and so put in appearance on behalf of the respondent number 4. Let notices be issued to the remaining respondents through registered AD and Dasti, returnable 6 weeks. In the meantime, no recovery shall be affected from the petitioner pursuant to the letters dated 28/1/2025 as well as 12/2/2025.
Yes.
It's 21/8/2025 annexure capital A and 12/2/2025.
That is also part of it.
दोनों का annexure A करते हैं ना. Of the writ petition.
Item 22.
Unless your lordship looks into para 12 of the Dilip Taluka's case.
Yes.
Para 12. Here, hundreds similarly persons have been already promoted. But there is a division bench order which says whether persons who were regularized in personnel post. Yes. Yes. We have seen the reasons recorded by the learned single judge for the impugned verdict and find that the post against which the writ petitioners were regularized were never added to the notified cadre in the department. Yet no plea was advanced for encadrement of the post held by the affected parties. The promotion in the department can only be considered from the eligible employees in the feeder cadre. and the writ petitioner being outside the cadre cannot have any enforceable right to claim promotion, particularly when the regularization order itself stipulates that they are regularized in post personal return. Here also the personal petitioners were appointed against the personal post. But similarly situated 100 posts, my lord, I have given all the documents. There's a small note, my lord, 1 page note that suffices all the briefings are there. Yes, sir. I think, yes.
Yeah.
About 100 posts have been, 100% have been.
Granted illegally.
My lord, I
They
understand.
can't, you
No,
can't-
so therefore, what I am saying, my lord, so encadrement petition is pending. That should be considered.
Huh?
Encadrement petition, not a single,
Where is that?
that is at your lordship will kindly find. Application page 447.
Huh?
Page 447. That in the note itself it is.
447.
Yes. Many petitions have been filed, many affidavits have been filed in this case. Because the first order was passed ex parte, the time was not allowed to my learned colleague, my lord. Whatever.
So this 447, what is that? 447 petition
447.
is pending before whom?
We have filed before the government. my lord.
That would be altogether different thing.
No, that is encadrement learned division bench has said, my lord. If you have any grievance, you can go for encadrement. But without encadrement also, they have promoted 100%. 100%.
It is altogether. You can very well.
Or they should have filed an affidavit in the case. In
No,
this
no,
case.
then you can very well claim this encadrment by filing a separate writ petition or whatever it may be. But
But
certainly if you are not, this Dilip Taluka, the case is.
On the basis of that,
You have moved this application on 7/3/2024.
that is an expertise husband, my lord. Expertise husband because.
7/3/2024, you have moved this application for encadrement.
Yes, my lord. This was, my lord.
This judgment was passed on September 2023.
This
So
judgment.
at that time, there was no application for encadrement.
That was not there. What I'm saying, my lord, this is an expertise judgment. My learned junior colleague, my lord, he took time from the court for deferment of the work. Despite this, because of the delay.
That's why only we are granting you.
I'm not blaming anybody, my lord.
That's why only we are granting you opportunity to argue the matter.
So
on
therefore, my lord,
merits.
what I am saying, my lord, I have very got limited scope in the matter. 2 points, my lord. Dilip Talukdar says, my lord, you have only one option. You can go for encadrement prayer is there. So if you can go for that. Otherwise, my lord, you cannot be promoted because you were appointed in personal response, regularized in personal. I am not there. But what my lord, effect is ultimately, my lord, all these petitioners, they are also working like the others. But the 100% have been already, they have promoted, my lord. Similar persons were appointed. So I'm saying, I'm not saying that I should be promoted. I'm saying, my lord, since there is another option before the authority, before the petitioner for considering encadrement. So I filed this petition, my lord, this should be considered. Encadrement, they should consider. If they rejected, my lord, I will have no opportunities, my lord.
No, so this judgment, the learned single judge simply said that
Because of the Dilip Talukdar.
Dilip Talukdar.
Yes.
Now, if you have applied you approach the government for encadrement,
Yes.
that is a separate cause of action. They'll consider it separately.
Separately, my lord, I did not have opportunities to file it before the learned single judge.
Because, sir, at that time you have not moved any application.
Did not file, so we wanted time because.
Application though, you have
what-
filed this application
what has
much after passing of this order, sir.
That is there, my lord. So this is the only option I have before your lordship.
Sir, देखिए, the-
Encadrement application filed and may be considered.
this writ appeal is filed by the appellants being agreed with the order dated 22/9/2023 passed by the learned single judge in writ petition number. What is the writ petition number?
I'll give the number. 5579/2023.
5579
2023.
2022.
3, my lord.
2023, whereby the prayer of the writ petitions, prayer of the appellants before the learned single judge before the writ court of directing the respondents state
For considering promotion, man.
for considering their candidature for promotion on the post of
LD,
on the post of
LD. LDA. Lower division is.
lower division assistant has been declined on the ground that since the petitioners, since the appellants are holding S cadre post and not holding any uncadred post, they are not entitled. Their candidate is not entitled for consideration in relation to the promotion on the post of LD. The learned single judge
LD. LD.
has relied upon the decision of the division bench of this court rendered in Dilip Talukdar and others of the state of Assam and others reported in 2017 to GLT 135. Good stop. Learned concept for the bench has submitted that though the division bench of this court has held that a person holding a ex-cadre post cannot be considered for the promotion on the post of higher post. But despite this fact, the state government has granted promotion to several other persons on the promotional post who are holding, who were appointed, who were appointed against the ex-cadre posts. So stop. Learned counsel has therefore submitted that after passing of the impugned judgment, the petitioners have already approached the state government. The appellants have already approached the state government with a prayer for encadrement of their posts, and the same is pending consideration with the government. Learned counsel for the appellant has submitted that
100%.
This court may please to observe that the dismissal of the writ petition filed on behalf of the appellants will not come in the way of, will not affect the right of the petitioners will not affect the right of the petitioners for consideration of their for consideration of their encadrement of the post which they are holding, and the state government should take a decision without being influenced by the impugned order passed by this court. The learned counsel appearing for the respondent has no objection if such observation is made while disposing of this writ appeal. Hence, this writ appeal is disposed of with the observation that the case of the petitioner appellants for encadrement of the post, if pending consideration with the state government and has not been decided till date, the state government shall take a decision on it without being influenced by the impugned order passed by this court in this, by the impugned order passed by the learned single judge in writ petition number so and so. That's all.
I'm deeply obliged. Only 100 similarly situated persons have been permitted. 100 illegally. Deeply obliged.
Item 25.
Maybe the lordship. By order dated 4/2/4.
The state government has not filed any reply.
Yes, ma'am.
Yes. The state government is supposed to file a reply. Who is appearing for the state government?
I should call him.
For them, why the pending petition is pending since long, why the state government is not filing response?
My lord, the counsel for the health department, I have asked him to.
Call him, pass over for the time.
Item 27.
Well, basically, they were supposed to have the instructions.
Supposed to clarify.
After the disposal of the petition, my lord, the appellant might have filed this review petition, my lord. In the review petition, the single judge, my lord, it has been cleared, my lord, that only the two petitioners, my lord. In the, this appellant, they have made as the private respondent, my lord.
Where is that?
My lord.
Petition was allowed. The benefit appears to have been given to all the 12 members. Confining the same by may not be proper and therefore.
আমি রিভিউ টু এগেইনস্ট এতে অ্যাকশন নাই মানে
রিভিউটো আমি সেই টাইম তো আপনি বলতাম রিভিউটো এজ ইট ইজ আপনি আপলোড দেখে রেডি করা এখন
Now you have to check this order.
No, my lord, these facts were brought to the notice. Naturally, my lord, even if the review is rejected, we will have to file the writ appeal only against the original order.
The original order, but the learned single judge, now you have to confine whatever your argument, you have to change this.
Yes.
Because earlier your submission was that it appears that this learned single judge has not taken into consideration, though it
No.
intended.
No, our case is similarly identically placed persons are entitled to identical relief. That is our case. Now, if your lordship would kindly have a look at this order, my lord. Please come to my lord, page number.
But the learned single judges again clarified that it confined only to those two petitioners and not to the petitioner.
Exactly. That is our case. Our case is learned single judge could not have because the benefit was given to all. Please come to that order, my lord, page 77.
Yes.
In the interest of public service and in compliance of the cabinet decision held on so and so on creation, reorganization of the cadre post under the Panchayat and Rural Development Department and in compliance of the order of the Honorable High Court dated so and so in the matter of Sri Dhiren Bhorali and another versus State of Assam and others for avoiding contempt proceedings drawn in contempt case number and as per the provisions of the Assam Panchayat and Rural Development Officers Technical Service Rule 15, and subject to reversion without assigning any reason thereof, Governor of Assam is pleased to promote. Now kindly see, my lord, serial number 1 is the appellant number 1. Serial number 1 to 4 are appellant number 1 to 4. And serial number 6 is appellant number 5. And this 7 and 11, Dhiren Bharali and so, they were petitioner number 1 and 2.
So why you have not mentioned this fact regarding dismissal of the review petition in the writ appeal?
No, no, in the miss case we have shown, my lord.
Huh?
In the miscellaneous IA, in the IA, we have written all these things. In the IA, we have brought on record, my lord. Even the order of review also.
Okay. If lordships permits me, my lord, that was used only to condone the delay, my lord. In the writ appeal, they have not annexed that. In fact, not challenged also, my lord.
No, no, even if review is rejected, eventually we'll have to file the original writ appeal against the original order.
I will file response, my lord. 3 weeks time maybe.
Then it, Mr. So-and-so put an appearance on behalf of the.
PNRD department. I'm yes. Response number 1, 2, 3, and 1, 2, and 3, my lord.
1, 2, and 3, and you are Mr.
B. Sharma for respond number 5, accountant.
And who is for the respondent number 4? Department of Finance.
Finance department. Well, my colleague is there.
You are- We can, only 5 respondents are there, no?
Yes,
Okay,
5
Mr. So-and-so
official respondents, my lord, 6 and
is
7.
appearing on behalf of the respondent number 1 to 4, and Mr. So-and-so is appearing on behalf of the 1 to 3. Mr. So-and-so is appearing on behalf of the respondent number 4. Mr. So-and-so is appearing on behalf of the respondent number 5. The learned respective counsels may file the response to the writ appeal within a period of
3 weeks, my lord. Or 4 weeks, 4 weeks, my lord.
4 weeks, list after 4 weeks.
I love this.
Item 28 and 29.
In this matter, I appeared for the HPCL lordship and I was led
You are
by
appearing for the HPCL.
lordship. I was led by Mr. BC Das lordship. Now, he has said that lordship, he would not be able to appear in this matter due to his health condition. So lordship, I have conveyed it to the authorities, but then I don't have any instruction as of now. So some accommodation lordship, I'm praying for.
We can learn concept appearing for the year.
Date may be given, my lord.
Huh?
Date may be given, February 24th, they filed the appeal, my lord.
Lordship,
Matter is pending.
Then concept, Mr. So-and-so appearing for the. In this, HPCL has submitted that. Earlier concept engaged by the HPCL, Mr. BC Das.
Lordship.
BC Das is not inclined to continue as advocate of the HPCL, and therefore the HPCL is required to engage a new concept, and for that purpose some time may be granted. List after
Any date convenient to you, Lord.
6 weeks, list after 6 weeks.
Obliged, Lord.
Item 30.
Yes.
In fact, Lordship, I had sought time to file an affidavit, but no instruction has come, Lordship may take it up. On the last occasion, Lordship, it was deferred on my prayer.
Okay, yes. Learned additional solicitor general. Mr. Chaudhary has submitted that. There is no requirement of filing any.
Since they have not responded.
affidavit to the rejoinder filed by the petitioner, and the matter can be heard.
Your lordship, date may be fixed for the.
We'll admit this and list it for the.
Indeed, your lordship, for the final
Having,
hearing.
having gone through the material available on record, we are of the view that matter requires consideration, hence admit. Parties are represented through their advocates, so no need to issue any formal notice. Lists this petition for the hearing in the month of July.
We can fix a date, your lordship.
You like date, Abhi? Take the date from the history.
Indeed, your lordship.
Item 31.
Please, your lordship.
Yes.
Your lordship, this is a matter for disability pension, and in pursuance to last order, your lordships had asked them to clarify the PPO, which is
Yes, lordship. I have received this affidavit today. I'll be filing it today itself, lordship. Let it come on next Monday, lordship.
Your lordship, they have already filed counter affidavit and they
That
have.
aspect has not been dealt with, lordship. What your lordship queries as per order dated 7th of March, lordship. That has not been replied in this affidavit. So I'm filing that affidavit today, lordship.
Yes, ma'am.
But my respectful submission, your lordships, in their counter affidavit under para 13, they have not disputed this PPO. They are admitting that the PPO
Now
was.
they are again trying to clarify it. Is there any problem in that, ma'am?
No problem. I leave it to my lords. Otherwise, this is a clear case.
Mr. B. Chakravarti, learned counsel, appearing for the respondents. I submitted that to clarify the disparity as observed by this court on 8/4/2025. An additional affidavit would be filed during the
Today itself, lordship.
during the course of the day. Mr. Please.
May I request my lords may have it on 26th of May, because my other matter is listed before your lordships and I will be coming to Guwahati High Court if subject to convenience of my lords.
26th of May.
I'm so grateful.
Much obliged.
Okay.
Item 32.
May it please, your lordship. My lord, my basic case would be, my lord. This rule 23, my lord, where, my lord, arising of vacancy has been made the basis. This is in conflict with the rule itself and therefore it is violative of Article 14. Now, if a lordship would kindly come to the rules, my lord. My lord, I have annexed the rule in my writ appeal. Please come to, my lord, page number 199. I am placing the provision of both the direct recruitment and the promotion, my lord.
Yes.
Rule 6, direct recruitment B.
Yes.
Before the end of each year, the government shall make an assessment regarding the likely number of vacancies to be filled up by direct recruitment during the next year and shall intimate the same to the commission together with the details about the reservation for candidates belonging to scheduled caste. Then my lord will kindly come to next page, my lord. Sorry, and same page, my lord. Page 200, the D. The commission shall furnish government with a list of candidates recommended by it in order of preference, found suitable for direct recruitment. Number of candidates in such list may be approximately double the number of the vacancies. Number 2, list mentioned in clause D and E of the sub-rule 1 of this rule shall remain valid for 12 calendar months from the date of recommendation. So when it comes to direct recruitment, my lord, once APSC makes the selection, then it will come to the appointing authority and thereafter it will remain valid for 12 months. And once appointments are, my lord, it comes to the hand of the administrative department, then appointments are made. So in case of direct recruitment, recruitment is the, my lord, criteria based on which one can claim seniority. Now regarding promotion, my lord will kindly come to rule 13. At page number 209.
Yes.
before the end of each year, the government shall make an assessment of the likely number of vacancies to be filled up by promotion in the next year in its cadre. Appointing authority shall then furnish to the selection board the following documents and information with regard to as many officer in order of seniority as 4 times the number of vacancies as assessed under sub rule 1. So these are the information, my lord, which appointing authority will furnish to the selecting authority. Then my lord will kindly come to page number 211. So the selection committee will make a list. Now rule 13.6 is very important, my lord, at 211, sub rule 6. Appointing authority shall consider select list prepared by the board along with character rolls and personal files of the employees and approves the list unless it considers change necessary, etc., etc. So, my lord, a list for promotion which should be prepared by the selection committee that has to be approved by the appointing authority under rule 13.6. Only when, my lord, the right of the promotee crystallizes for appointment. Now, if this is the scheme of the rules, now kindly come to the impugned rule 23, my lord, at page number 220, 20 sub rule 3. A member appointed by promotion against the vacancy occurring in a year shall be senior to the member appointed by direct recruitment of that year. So, my lord, whether under rule 13.6, the select list has been approved or not. Now, it is the arising of the vacancy which has been made the basis for giving seniority to the promotee. Now, have it been a case, my lord, where direct recruitment and promotion takes place in the same year, and in which case, my lord, promotee is given senior, there is no dispute. That is normally the position. For example, that my lord, J.B. Patnaik's case, which the Supreme Court was considering, that was also a rule of the similar nature. Therefore, my lord, in paragraph 21 and 22, I have explained the position. Hmm? 22, 3 and 23. Yes. Yes. My lord, if your lordship kindly permit me to read 2 paragraphs, everything will be clear, my lord. Page 38. And lordship knows the facts. We were promoted, we were appointed following direct recruitment on 21/9/22, and they were promoted, my lord, on 6/1/23. And in the scheme of the rule, year is defined as a calendar year, not even a financial year. Now, please come to page 38.
Yes.
Impugned rule 23 is in conflict with rule 2J, rule 6.1A, rule 6.1D, rule 13.1 and 11C, read with article 14 and 16 of the Constitution of India. Impugned rule 22.3 envisages a situation wherein a promotee is entitled to count their seniority based on occurrence of vacancy in a year, while a direct recruit like the petitioners can count their seniority based on recruitment made in a year. There is no dispute that if occurrence of vacancy is to be made the basis for conferring seniority to a promotee, in that situation, Rule 13.6, which provides that appointing authority shall approve the list prepared by the selection board for promotion, would be rendered odious. Otherwise, a promotee can count his seniority from a date when he is not even born in the post or the cadre. That being the admitted position, the impugned Rule 22.3 is ultra vires the rules read with Article 14 and 16 of the Constitution of India. Then para 22, that from the scheme of the recruitment rule, what is evident is that in case of a direct recruitment, an incumbent stands directly recruited under Rule 6 only upon publication of the select list under Rule 6(2). Similarly, a promotee stands posted only upon approval of the select list by appointing authority prepared by the selection board under Rule 13(6) of the rules. In other words, a promotion under the scheme of the rule takes effect only upon approval of the select list by the appointing authority under Rule 13(6). But curiously enough, much to the prejudice of the direct recruit, impugn rule makes occurrence of vacancy as the basis for conferring seniority, which is expressly discriminatory qua direct recruit, and hence this rule 22(3) is liable to be adjusted and declared as ultra vires. This is my basic case, Milord. And there are case laws and all, Milord, including Milord. Now, if your lordship will kindly permit me to place the J.B. Patnaik's case, Milord. Yes. Milord, 1998, 4 SCC 456. But we can resume at 2 o'clock. But I was referring to the one judgment, Milord. Yes. 1998, 4 SCC 456. Milord, here I'll be placing reliance on the rule which was involved in this case and the interpretation given by the Supreme Court on the rules. Please come to para 24, Milord, at page 464. Seniority. When officers are recruited by promotion and by direct recruitment during the same year, promoted officers shall be considered senior to the officers directly recruited, irrespective of the dates of joining the appointment. So in our rule says, Milord, when it comes to direct recruitment, it would be based on date of recruitment, and in case of promotee, the incident of, Milord, accrual of the vacancy. Now here it says during the same year or during the same recruitment year. Now, like in the context of this rule, a particular argument was advanced at para 34, and which is very relevant in our case, my lord. That's why I'm referring to this. Please come to page 469, para 34. The only other contention which requires consideration is the one raised by Sri So-and-so, learned senior counsel appearing for the intervener, to the effect that the expressions recruitment and appointment have two different concepts in service jurisprudence, and therefore, when Rule 26 uses the expression recruited, it must be a stage earlier to the issuance of the appointment letter, and logically should mean that when the selection process started, and that appears to be intendment of the rule makers in Rule 26. This was the contention. We are, however, not persuaded to
this now the controversy is similar to that N.R. Parmar case.
Yes.
And now the matter is pending with the
larger bench, larger
Supreme Court in Hariharan case.
Yeah, Hariharan case.
The case.
Yes. If you also would kindly permit me to complete this parameter, yes. It is relevant in this case. Just this paragraph, no other paragraph. We are, however, not persuaded to accept this contention, since under the scheme of the rules, a person can be said to be recruited into service only on being appointed to the rank of assistant engineer, as would appear from Rule 6 and Rule 5 and 6. Then again, in case of a direct recruit, though the process of recruitment starts when the Public Service Commission invites application under Rule 10, but until and unless government makes final selection under Rule 15 and issues appropriate order after selected candidates are examined by the medical board, it cannot be said that a person has been recruited to service. That being the position, it is difficult for us to hold that in the seniority rule of expression, recruited should be interpreted to mean when selection process really started. That apart, the expression recruited applies not only to direct recruits, but also to the promotees. This is important. In case of a direct recruit, the process of recruitment starts with the invitation of application by commission. And in case of promotee, it starts with nomination made by the Chief Engineer Rule 16. But both in case of direct recruit as well as in promotion, the final selection vests to the state government under Rule 15 and 18 respectively. And until such final selection is made and appropriate orders passed thereon, no person can be said to have been recruited to this service. In this view of the matter, the only appropriate logical construction that can be made of Rule 26 is the date of order under which persons are appointed to the post of assistant engineer is the crucial date for determining seniority under the said rule. See, Mr. Raju Ramachandran's contention therefore cannot be sustained. Now, please apply this principle to our case, my lord. Under Rule 6, 1 and 2 regarding direct recruitment and regarding, my lord, promotion, Rule 13, 6. The moment under 13, 6, the selection made by the selection committee is approved by the appointing authority, then the promotee's right crystallizes. So, my lord, now if that be the position, now if based on occurrence of vacancy, a seniority is to be given, then, my lord, it defies the very logic. So, therefore, my humble submission is, my lord, for the present, lordship will stay the interim order. And, my lord, for the present, I do not intend to make any further argument, my lord. This is my limited argument for the purpose of admission. And I'm also praying for an interim order, my lord. Based on the interim order, no further promotion should be made. Yes, that is my humble submission.
Lordship, this case is ready for hearing, Lordship. In fact, we have already filed my affidavit. Private respondents have also filed their affidavit. So I think, Lordship, this matter is ready for hearing. I'm ready for hearing, Lordship. So, Lordship, one gradation list was published on 17/9/2024, Lordship. That is paid.
Not in dispute. The facts are not in dispute. You just, what is the justification in this, incorporating this Rule 22(3)?
Lordship.
That justification you have to satisfy.
Pardon, Lordship.
What is the justification of incorporating this Rule 22(3) which says a member appointed on promotion against the, in the year shall be senior to the member appointed by the recruitment of that year?
Lordship, in Assam, this rule is followed across the departments, Lordship. All the departments are following this procedure.
Validity is a
Yes.
challenge.
Lordship, initially, it was not the grievance of the petitioners that this rule is not violative of provisions of the Constitution. Initially, it was the grievance of the petitioner that they were not given seniority or they were not assigned seniority in terms of the rules, Lordship. That was the initial grievance.
In terms of the
Rules.
No, that's right. That is a separate grievance. In terms of the rules, if this, the seniority has been provided, that is a separate grievance. Here they have come with this, that they are the direct recruitees and admittedly appointed on a prior date, the date on which the respondents were granted promotion. So these persons cannot be placed above them in the seniority because their promotion was also subsequently. And the government is taking aid of this Rule 22(3), which they are saying is unconstitutional for the reasons they mentioned.
Yes, I'm coming to Lordship. If Lordship comes to page 38 of the petition, Lordship.
38.
Yes, Lordship. Two paragraph, Lordship, I would like to read. That is paragraph.
They already referred to.
Yes, I'm coming to, Lordship. paragraph 21 and paragraph 24. Two
Yes.
paragraphs, Lordship. First, I would like to read paragraph 24.
24.
Yes, that is page 40.
Yes.
It states, Lordship, that had it been a case where direct recruitment and promotion are made in the same year, in such a situation, there could be a legitimate justification of conferring seniority to the promotees over the direct recruit, but the impugned Rule 22(3) confers seniority upon the promotees based on occurrence of vacancy in the promotional quota, which is ex specie unconstitutional and aberrant. These petitioners were promoted, the respondents were promoted on 6/1/2023.
Yes.
Vacancies were of 2022.
That's right.
As per this provision, Lordship, if they would have appointed 6 days prior,
6 days.
that is within the year 2022, then they would not have any grievance against the respondents. That is what paragraph 24.
Their case is that they were appointed in the year 2022.
Yes.
Okay.
No, Lordship.
And these respondents were promoted in the year 2020.
23.
23.
23. Now they're saying that since their promotion is of a subsequent date and therefore they cannot be placed above in the seniority list, in the gradation list. This is what they now you have taken the course of this 22(3). They're challenging the validity of this provision.
Lordship, they were assigned seniority as per 22(3).
Yes,
As on date, Lordship, 22(3) is valid.
no doubt. But
So only question what they are questioning is the validity of 22(3).
yes,
They have no other ground except 16(1).
whatever the ground, but they are challenging that this is unconstitutional for these reasons.
Yes.
The reasons they have allocated in para number 20 and 21 or 21 and 22.
So far as that is why, Lordship, I'm trying to read paragraph 21 and subsequent paragraphs, Lordship.
Yes, read.
Lordship, so far as 21 is concerned, Lordship,
Yes.
21 says the impugned Rule 22(3) is in conflict with Rule 2J. Lordship, may kindly say first what is 2J, Lordship? This is definition clause, Lordship. Year means a calendar year.
Yes.
22J, year means a calendar year.
Yep.
Next clause is, Lordship, 6(1)(a).
Yes.
6(1). Lordship, may kindly see 6. This is for direct recruitment.
Yeah.
Lordship, may kindly read 6(1). 6(1), Lordship.
Yes.
Subject to sub-rule 3 of Rule 11, direct recruitment to cadres of assistant engineers, assistant architects, and assistant research officers, road research laboratories shall be made by the governor on the basis of selection made by the commission in accordance with the procedure hereinafter provided. Lordship, may kindly see A.
Yes.
Before the end of each year, the government shall make an assessment regarding the likely number of vacancies to be filled by the direct recruitment during the next year. Lordship, may kindly note this word next year. So far as direct recruitment is concerned, I have to assess the post for the next year. Then D, Lordship. The commission shall furnish government with a list of candidates recommended by it in order of preference found suitable for direct recruitment. The number of candidates in such a list may be approximately double the number of vacancies. So this is another clause. Third clause that is most important, Lordship. 11, Rule 11.
Yes.
This is promotion as assistant engineer.
Fine.
So there is a specific rule, Lordship, for the purpose of considering promotion to the post of assistant engineer. And what does it say, Lordship? The appointing authority shall publish in the government gazette annually the number of vacancies in the respective cadres of assistant engineers which have occurred or likely to occur in the year, not in the next year. That is the current year. Why I am trying to signify this paragraph, Rule 11, Lordship. If Lordship comes to Rule 13, That is the general procedure for promotion. Rule 13, Lordship. General procedure for promotion.
Yes, sir. Yes,
Before the end of each year, government shall make an assessment of the likely number of vacancies to be filled up by promotion in the next year in each cadre. So there is a direct recruitment for the next year, for other categories for the next year. But so far as promotion to the cadre of assistant engineer is concerned, in the current year.
no. This, before the end of the government shall make an assessment likely number of the to be filled by promotion in the next year.
Lordship just read Rule 11 that applies to assistant engineer directly. So this has to be read that this 13(1), it applies for other posts, not to the post of assistant engineer.
You mean to say that for the purpose of this assistant engineer, altogether a different rule is there?
Yes, what I'm trying to say, Lordship, for the purpose of promotion to the post of assistant engineer, the recruitment has to be completed during the same year, that is in the current year.
Or for the other promotional posts, the
Assessment for the next year.
For the next year vacancy.
Now, if Lordship comes to Rule 13(3),
Yes,
other provisions are general, but this 13(1) is distinguishable from 13(1), 11(1). 13(3), Lordship, the appointing authority shall simultaneously request the selection board to recommend within 1 month a list of officers found suitable for promotion in order of preference in respect of promotion to each of the cadres in which recruitment is to be made by promotion. So it's a time bound. If Lordship again comes to 13(8), the select list shall remain valid for 12 months from the date of approval by the commission. That is another issue, Lordship. Then 10, Lordship, 13(10). The select list as finally approved. 10, Lordship, 13(10).
13(10) is not,
Rule 13(10).
was added later.
13, Lordship, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
10 is not there, Mr. Chaudhary.
Yes, my lord.
Your this 10 is not there, sub rule 10.
Rule 13.
That
is the unamended rule. It was amended later on.
The one I have annexed, it is not there.
It is not there. It is in the.
Ten to কিছ? এইটো 10 মতে হ'ব লাগিব এতিয়া, আগতে 6 আছিলে।
So this is another time bound schedule, Lordship. The select list as finally approved shall be published by the appointing authority in the Assam within 15 days from the date of approval.
Yes.
So what I'm trying to emphasize, Lordship, so far as promotion to the post of assistant engineer is concerned, we have to complete the entire process within the same year. That is, if in this case, Lordship, if the vacancies are of the year 2022, we have to complete the process in the year 2022 itself. And that is why I am referring to paragraph 24 of the petition, Lordship. That is why I am saying, if they would have appointed 6 days prior, Lordship, then the petitioner would not have any objection so far as their seniority is concerned. That is what paragraph 24. Now, if Lordship comes to my affidavit, Lordship,
Yes.
there I have stated why this delay has occurred.
Yes.
Paragraph 14 to the 14 to first. Paragraph 14, Lordship.
Your affidavit is at page.
Page Lordship 521.
Secretary to the Government of Assam.
Yes, Lordship.
Yes.
We do.
521.
521, Lordship, paragraph 14.
Yes.
That as regards to the amendments made in paragraph 18 of the incident petition, the deponent begs to state that as per Rule 11.3 of the Assam Engineering PWD Service Rule 1978, as amended, which prescribes that 30% of the total cadre strength of assistant engineers in the department are to be filled up by way of promotion from the post of junior engineers. Accordingly, the department maintains two separate post-based 100-point roster, registers for promotee assistant engineers for 227, that is 30% Lordship, and directly recruited assistant engineers for 529 posts. It is pertinent to mention that junior engineers are promoted to the rank of assistant engineers in accordance with the vacancies arising in the roster registers of promotee assistant engineers. As such, the vacancy year of the post against which a junior engineer is promoted can be clearly ascertained. Further, Rule 5 of the Assam Engineering Service Rule 1978 as amended prescribed the method of recruitment to the post of assistant engineer, wherein recruitment to the post of assistant engineer by way of direct recruitment shall be made in accordance with Rule 6 of the rules of 1978, and recruitment to the post of assistant engineer by way of promotion from junior engineers shall be made in accordance with Rule 11, 13, 14 of the rules of 1978. Further, the selection list for promotion to the rank of assistant engineers in the matter of respondents number 3 to 98 has been approved by the appointing authority and published by notification dated 17/12/2022. As per Rule 13 of the rules of 1978. However, following some administrative formalities, promotion notification could be issued on 6/1/2023. Further, Rule 22.3 clearly states that a member appointed by promotion against a vacancy occurring in a year shall be senior to a member appointed by direct recruitment of the year. As such, the date of year occurring the vacancies in the matter of the petitioner being directly recruited may not have any significance under the provisions of Rule 22.3 of the Assam Engineering PWD Service Rule 1978. Also, the vacancy year of the post against which a junior engineer is promoted can be clearly ascertained as a separate post based on 100-point roster registered for promotee assistant engineers for 227 posts is maintained in the department. In this regard, it is pertinent to mention that since the vacancies arose in the year 2022, from the roster mean for promotee assistant engineers, the department took urgent necessary action to fill up the vacancies in the year 2022. Accordingly, a DPC was held on 7/12/2022 and select list was published on 17/12/2022. However, following some administrative formalities, promotion notification could be issued on 6/1/2023. Then, Lordship, I'm coming to 16, Lordship. That as regards to the averments made in paragraph 22 of the instant writ petition, the deponent begs to state that the contention of the petitioners is not correct. The junior engineers who are already government servants are only promoted to the rank of assistant engineer subject to fulfilling of the conditions set in Rule 11.4 of the rules of 1978. Herein, the respondents number 3 to 98 are promoted after rendering more than 8 years of service to the government. In fact, these respondents are on the verge of retirement, Lordship, although 8 years is the qualifying years. Further, as per Rule 11.3 of the Assam Engineering Service Rule 1978, as amended, which prescribes that 30% of the total cadre strength of assistant engineers in the department are to be filled up by way of promotion of junior engineers. Accordingly, the department maintains two separate
Yes,
524, Lordship. Further, as per Rule 11.3 of the Assam Engineering PW Service Rule 1978 as amended, which prescribes that 30% of the total cadre strength of assistant engineers in the department are to be filled up by way of promotion of junior engineers. Accordingly, the department maintains two separate post-based 100-point roster registers for promoted assistant engineers for 227 posts and direct recruited assistant engineers for 529 number of posts. It is pertinent to mention that junior engineers are promoted to the rank of assistant engineer in accordance with the vacancies arising in the roster register of promoted assistant engineer. As such, the vacancy year of the post against which a junior engineer is promoted can be clearly ascertained. Further, Rule 22.3 confers seniority to promoted assistant engineers over direct recruited assistant engineers, considering the long years of service by the promoted assistant engineers rendered to the government, and also junior engineers are usually promoted to the rank of assistant engineers at later end of their career stage, who are on the verge of retirement. Seventeen, Lordship. As regards to the averments made in paragraph 21 of the instant petition, the deponent begs to state that the contention of the petitioners is not correct. Rule 2J defines a year as calendar year to clear the confusion with financial year. Further, Rule 6 prescribes the process for selection of a direct recruited assistant engineer for appointment, while Rule 11, 13, 14 sets the condition for promotion of a junior engineer to the assistant engineer. Further, Rule 22.3, which states a member appointed by promotion against a vacancy occurring in a year shall be senior to a member appointed by direct recruitment of the year, only prescribe the seniority to be accorded in the event where a promoted assistant engineer who has been promoted against a vacancy of a year and a direct recruited assistant engineer has been appointed in the same year. Further, promoted assistant engineers and direct recruited assistant engineers are appointed against separate post-based 100-point roster registers. As such, Rule 22.3 is no way violates Article 14 and 16 of the Constitution or is in conflict with the said rules. Then, Lordship, paragraph 22.
yes,
That as regards to the averments made in paragraph 26 of the instant writ petition, the deponent begs to state that Rule 22.3, which states a member appointed by promotion against a vacancy occurring in a year shall be senior to a member appointed by direct recruitment of the year, only prescribe the seniority to be conferred in the event where a promoted assistant engineer who has been promoted against a vacancy of a year and a direct recruited assistant engineer who has been appointed in the same year. Further, Rule 22.3 confers seniority to promoted assistant engineers over direct recruited assistant engineers, considering the long years, more than 8 years of service by the promoted assistant engineers rendered to the government. And also, junior engineers are usually promoted to assistant engineers at the later end of their career stage who are on the verge of retirement.
yes.
Lordship, in this matter, Lordship, we have also taken the views of the personnel department as well as judicial department, Lordship, that your Lordship may see at paragraph 24, Lordship.
Yes,
24, paragraph 8, Lordship, not 20.
yes,
Page 515, Lordship.
yes,
That as regards to the averments made in paragraph 9 of the instant petition, the deponent begs to state that the PWD divided endorsement dated 26/4/2023, that is e-file number so and so, has sought for the views of personnel department regarding the seniority of the said 106 numbers of promoted assistant engineers. Accordingly, the personnel department by its endorsement dated 26/5/2023 in e-file number so and so has requested the PWD to refer to Rule 22.3 of the Assam Engineering Service Rules 1978, which states a member appointed by promotion against a vacancy occurring in a year shall be senior to a member appointed by direct recruitment of that year. And further opined that the 106 numbers of junior engineers who were promoted against vacancy of the year 2022 and notified in 2022 2023 will be senior to those direct recruits of the year 2022. Further, the PWD by its endorsement dated 13/6/2023 in e-file number so-and-so has sought for the views of Judicial Department regarding seniority of the assistant engineers PWD in the inter-se seniority list amongst the direct recruited assistant engineers of the year 2022 and the 106 numbers of assistant engineers promoted for the engineer from the junior engineer civil who were selected on 7/12/2022 against the existing vacancies of the year 2022, and select list was published on 17/12/2022, but notification for promotion was issued on 6/1/2023. Accordingly, the Judicial Department by its endorsement dated 13/7/2023 offered its views wherein it clarified that as far as the directly recruited assistant engineers of the year 2022 are concerned, it is observed that the date of or year of occurring the vacancies may not have any significance under provisions of Rule 22(3) of the Assam Engineering PW Service Rule 1978. Further, concerning the 106 numbers of assistant engineer promoted by notification dated 6/1/2023, their recommendation for promotion was admittedly made against the vacancies of the year 2022, and select list has been issued on the year 2022. Therefore, for all practical purposes, this group of promotees are to be treated as having been promoted against the vacancies of 2022. Further, the Judicial Department opined that the 106 numbers of assistant engineers promoted by notification dated 6/1/2023 against the vacancies of the year 2022, irrespective of the date of their promotion notification, are senior to the assistant engineers appointed by the direct recruitment of the year of the same year of 2022 by operation of Rule 22(3) itself. Accordingly, the 106 numbers of junior engineers who were promoted against vacancy of the year 2022 and notified in 2023 will be senior to those direct recruits of the year 2022 as per rules. Further, a group of direct recruiting assistant engineers civil for the year 2022 by their letters number dated 11/9/2023 and 9/4/2024 have submitted their prayer petition to the PWRD to consider their names above. The 106 numbers of assistant engineers promoted by notification dated 16/1/2023. Accordingly, on receipt of the prayer petition dated 11/9/2023 and 9/4/2024, the PWRD by its endorsement dated 2/7/2024 in e-file number so and so.
These are the facts, okay? Yes.
At page 537, that is the minutes of the selection board lot.
Okay, that's right.
Yes. Okay.
So you are saying that you are justified in granting seniority to the respondents over and above the petitioners in view of the Rule 22(3) and the Rule 22(3) is not ultra vires to the. Yes.
Lordship, one citation, Lordship, please, Lordship, I would like to place Lordship. Only one citation, Lordship. That is 1967-65 ITR 34. Yeah, sir. 1967.
Party number B.
So this is S. Jaisinghani versus Union of India. 5. Second page, Lordship.
Just.
Second page, Lordship.
Yes.
Paragraph 2, Lordship.
Yeah.
Although the Rule 22 has been challenged, Lordship, from the petitioner's side, nothing has been argued on what ground, Lordship, this Rule 22(3) is violative of Article 16 or any other provisions of law, Lordship. Paragraph 2, Lordship. In his petition under Article 226 of the Constitution, the appellant S.G. Jaisinghani challenged the constitutional validity of what has been described as the seniority rule. I'm coming to the next paragraph, Lordship, paragraph 3. In order to improve the income tax administration, the Government of India on September 29, 1944, reconstituted and classified the existing income tax services as Class 1 and 2. The reorganizational scheme provided for recruitment of income tax officers Class 1, grade 11, service partly by promotion and partly by direct recruitment. The reorganizational scheme was set out in Government of India Finance Department Central Revenue, letter dated September 29, 1944. It creates two classes of income tax services, Class 1 with grade 1 and grade 2, and Class 2 services with grade 3. Recruitment rules, recruitment to Class 1, grade 2 service was to be made A, by direct recruitment through a competitive examination, and B, by promotion from Class 2, grade 3. The ratio prescribed in para 2D of the letter being 80% by direct recruitment and 20% by promotion from Class 2, grade 3 services. And in case sufficient numbers of suitable candidates was not suitable for promotion, surplus vacancies would be filled by direct recruitment. In Government of India Ministry of Finance Revenue Division, letter dated January 24, 1950, the rules of seniority were laid down. These rules laid down the principle for determination of seniority A as between direct recruits recruited on the result of the combined competitive examination. B, as between promotees selected from Class 2, and C, as between the direct recruits who complete their probation in a given year and the promotees in the same year for appointment to Class 1. These rules were revised on September 5, 1952 by the Government of India Ministry of Finance Revenue Division, letter number so and so, dated September 5, 1952. Yeah. The relevant rule is the Rule 1F as framed in 1950 was as follows. The seniority of direct recruits recruited on the results of the examination held by the Federal Public Service Commission in 1944 as subsequent year shall be reckoned as follows. 1. Direct recruits of an year of an earlier examination shall rank above those recruited from subsequent examination. We are not concerned.
Ratio of the judgment, you show us the ratio of the.
We are concerned with 3, Lordship. 3. Just read. I'm reading paragraph that revision of 1950, Lordship.
Yes.
I'm reading 3, Lordship.
Yeah.
The promotees who have been certified by the Commission in any year, any calendar year, shall be senior to all direct recruits who complete their probation during that year or after and are confirmed with effective from a date in that year or after. Now, Lordship, this provision was again revised in the year 1952.
Yes.
If Lordship comes to that portion, Lordship,
Yes.
this rule are revised in 1952 was to the following effect. I am straight coming to 3, Lordship,
Yes.
small Roman T. Officers promoted in accordance with the recommendations of the Departmental Promotion Committee before the next meeting of the Departmental Promotion Committee shall be senior to all direct recruits appointed on the results of the examinations held by the Union Public Service Commission during the calendar year in which the Departmental Promotion Committee met and the 3 previous years. Now, Lordship, meaning is
Yes.
direct recruitment of 2022. I'm just example, Lordship. I'm taking the 2022. Direct recruitments of 2022 shall be junior to those promotees who were recommended by the DPC met in 2022. If I am a direct recruitee of 2022, I am going to be junior to those promotees, Lordship, if I am recommended by the committee in the same year.
How the court has interpreted?
Then I am coming to 7, Lordship, paragraph 7.
Yes.
Paragraph 7. The full bench of the Punjab High Court rejected the writ petition of the appellant, holding that principles for determining seniority between direct recruits and promotees laid down in Rule 1F3, just now I read, Lordship, and 4 of 1952 were not discriminatory, and there was no infringement of Article 14 and 16(1) of the Constitution. Next page, Lordship. Next paragraph, Lordship. 8. The first question to be considered in this appeal is whether Rule 1F3 of the seniority rules, as framed in 1952, violates the guarantee under Articles 14 and 16 of the Constitution. I'm coming to paragraph 9, Lord. Paragraph 9. The relevant law on the subject is well settled. Under Article 16 of the Constitution, there shall be equality of opportunity for all citizens in the matters relating to employment or appointment to any office under the state or to promotion from one office to the higher office thereunder. Article 16 of the Constitution is only an incident of the application of the concept of equality enshrined in Article 14 thereof. It gives effect to the doctrine of equality in the matter of appointment and promotion. It follows that there can be reasonable classification of the employees for the purpose of appointment or promotion. The concept of equality in the matter of promotion can be predicted only when the promotees are drawn from same source. In the preferential treatment of one source in relation to the other is based on the differences between the said two sources, and the said differences have a reasonable relation to the nature of the office or offices to which recruitment is made. The said recruitment can legitimately be sustained on the basis of valid classification dealing with the extent of protection or of Article 16(1) of the Constitution. This court observing so and so several citations has been given, Lordship. I'm coming to 10, paragraph 10. Just 3-4 lines, Lordship. We next proceed to consider the argument of the appellant that the rule of promotion from income tax officers class 1 grade 2 to class 1 grade 1 is discriminatory in character. It was contended that while a direct recruit has to put in 5 years as income tax officers class 1 grade 2, a promotee officer gets into grade 1 with a minimum of 1 year service in the class 1 grade 2. The other 4 years being counted in class 2 grade 3. It was therefore submitted that the rule operated against the direct recruit in a discriminatory manner. In our opinion, there is no substance in the contention of the appellant. Once it is held that the rule of seniority enacted in Rule 1F3 is legally valid, the rule of promotion, that is Rule 4, Chapter 4 of the Central Board of Revenue Officers Manual, cannot be held to be lead to any discrimination between the direct recruits and the promotees. Lordship, that is the basic submission, Lordship. Here, Lordship,
Ultimately, what the Supreme Court has held.
that is, Lordship will find that paragraph 15 and 16. It was partly allowed.
That directly, sir.
Paragraph 15, Lordship, partly allowed means so far as that this discrimination part is concerned, Supreme Court upheld the same. Paragraph 15, Lordship. We should also like to suggest to the government that the future years, direction was issued for future years, the roster system should be adopted by framing an appropriate rule for working out the quota between the direct recruits and the promotees that we have already done, Lordship. For what, and that a roster should be maintained indicating the order in which appointments are made by direct recruitment and by promotion in accordance with the percentages fixed under the statutory rule for each method of recruitment. 16. For these reasons, we allow this appeal in part and order that a writ in the nature of mandamus should be granted to the appellant to the extent indicated above. There will be no order as to cost in this appeal. So basic my submission is that this rule 22(3), which is exactly similar to this rule 1(f)(3), Lordship.
So its validity has been upheld here in this matter.
No, court said, Lordship, this granting seniority to the promotees above the direct recruits is not discrimination, Lordship, to anyone, Lordship, and further, it is not violative of Article 16 of the Constitution.
That precise finding of the Supreme Court, sir.
Paragraph 8, Lordship.
Paragraph
8.
8.
Yes, sir.
You just please focus on that precise finding.
Then I'm coming to paragraph 9, Lordship.
Again, 9, okay?
Yes, paragraph 9, Lordship. I'm starting from the last 5 lines. Yeah.
Last 5 lines.
It follows that. It follows that.
Yes.
It follows that there can be a reasonable classification of the employees for the purpose of appointment or promotion. The concept of equality in the matter of promotion can be predicted only when the promotees are drawn from the same source. In the preferential treatment, of one source in relation to the other is based on the differences between the said two sources, and the said differences have a reasonable relation to the nature of the office or offices to which recruitment is made. The said recruitment can legitimately be sustained on the basis of a valid classification dealing with extent of protection of Article 16 of the Constitution.
Yes. Yes.
So in our case also, Lordship, recruitment to the post of assistant engineer are done from 2 sources, Lordship. One by direct recruitment, one from the assistant engineer, Lordship. So that is my basic submission, Lordship. Thirdly, Lordship, this promotion was granted in the year 23 itself, 22-23. Since then, Lordship, now it is 25. Now the rule has been silenced, Lordship. Even if your Lordship prefers to interfere with the rules, Lordship, your Lordship holds that this is violation of Article 16 or 14, whatever. Lordship, whatever promotion they have got, Lordship, it is as per the provisions of existing rules, Lordship.
Yes.
That is my basis.
Yes.
May it please your worship. My lord, for easy reference of the court, I have prepared the sequence of dates how it's proceeded. I have included in my body of my affidavit in opposition, but after the government has filed an affidavit, I have incorporated 3-4 dates from their affidavit also. Now your lordship has seen, I'll just refresh the sequence of events, my lord. First date is 19/11/2019. This was the date, my lord, on which the APSC issued an advertisement for filling up of direct recruitees. Your lordship has seen in the rule that there are 2 channels of promotion. One is for the direct recruit and the promotee. For promotee, it is 30%. From direct recruit, it is 70%. Now, after 19/11/2019, initially there were 156 posts. Then they issued an addendum and another 104 posts were added.
Then on 27/6/2022, for the first selection board meeting for promotion of the 83 numbers of junior engineers were held. Initially, my lord, they came before this honorable court challenging. This 83 doesn't include now.
156 posts for direct recruitment. Again, it was 104 additional posts were also for direct recruitment.
Yes.
Okay.
Now, initially, my lord, on 27/6/2022, my lord, selection board meeting was held for promoting 83 numbers of junior engineers, my lord.
Fine.
They initially challenged this appointment. I've come to the writ petition order. They got an interim order saying that all promotion in regard to these promoters were withheld. But in terms of the orders of the court. Later on, when
27/6/2022.
yes. Initially, they challenged. Now, when we pointed out from the list of dates that these are admittedly promoted prior to your date of appointment, now they have excluded this 83. In the present respondent, these 83s are not there.
How their promotion, they were got promotion on which date?
27/6/2022, 27/2022, they were promoted, and the direct recruit were promoted on the next date, 21/9/2022.
Direct recruit were not promoted.
Oh, sorry, direct recruit were appointed. Sorry, sorry. Direct recruited were appointed on 21/9/2022. Next
Okay.
date. So admittedly, they were
83
yes.
persons now they have.
Now, for the promotees, my lord, the selection body meeting was held on 17/12/2022.
17/12. Okay.
Yes. Then Honorable Chief Minister approved it on 16/12/2022.
Okay.
Then select list was published on 17 to.
If they, the select list was prepared on 17/12/22, Chief Minister approved prior to that, okay?
No, after that.
After that, how can the 16/12/2000 Honorable Chief Minister approved the said select list? Select
Yes.
list was published on 17/12/2022.
No. Your lordship will see. Subject.
It is your
Yes.
compilation of.
Yes, it's correct.
Submitted.
7/12/2022 selection board meeting was held.
Yes, 7/12/22 selection board was held.
Yes, and 106 were recommended by the selection board for the existing vacancies of the year 2022.
And ultimately, the approval was granted on 16/12/2020.
Yes.
Select list was published on 17/12.
Yes, correct.
Then
my lord, 4/1/2023, the Honorable Chief Minister approved the place of posting.
okay.
Then 6/1/2023, the notification was issued promoting the 106 numbers of junior engineers.
Fine.
Then your lordship will find the direct recruiters, they filed a representation on 17/3/2022.
Yes.
Then views of the personnel department was shot on 26/4/2023. Then personnel department expressed his views on 26/5/2023.
Yes.
Then your lordship will turn to the next page. Then on 13/6/2023, the judicial department views was shot. Then 13/7/2023, the judicial department gave the views. Then your lordship will find on the 8/3/2024, one person was promoted. He is not before your lordship now. So your lordship is not concerned with 8/3/2024. This gentleman named Jayanta Kumar Goswami. Then on 9/4/2024, the direct recruiters again submitted a representation. Then on that representation, 2/7/2024, the views of the personnel department was shot. And on 19/7/2022, the personnel department reiterated the earlier views that these are all vacancies of 2022. Then on 2/9/2024, the provisional interstate seniority list was published. Then against the provisional interstate seniority list, representation was submitted on 5/9/2024 and 13/9/2024. It was rejected, my lord. Then when the representation was rejected, my lord, they came before this honorable court on 16/9/2024. Order dated 16/9 passed by this honorable court in WBC number so-and-so, entirely directed to dispose of the representation of the direct recruits, and until such time, no further promotion from the joint cadre of assistant engineer of PWD. Then, my lord, on 17/9/2024, the interstate seniority list was, final list was published. Then against that, my lord, the direct recruits submitted a representation. Then on 25/11/2024, all the aggrieved petitioners were invited for a personal hearing. Then on 29/11/2024, the petitioners were heard in person. Then next page, your lordship will find the 29/1/2025, the PWD department could not consider the prayer of the direct recruits. Then, my lord, the 31/1/2025, my lord, the Honorable Cabinet Assam allowed one-time relaxation of the qualifying services for promotion from 5 years to 2 years. Then, my lord, the 17/2/2025, this was challenged. Then the Honorable Court initially issued a notice, my lord, no interim. Then 3/3/25, my lord, the PWD again granted a relaxation in terms of the rules. Then 6/3/2025, additional affidavit was filed in WBC number so and so. Then these affidavits were filed. And on 24/3/2025, my lord, when the Honorable Court was about to dismiss the writ petition, my lord, then they withdraw this writ petition saying that they will challenge this rule. Then, my lord, on 27/3/2025, these affidavits were filed. So far, my lord, this present writ petition is concerned, my lord. I don't know, my lord, how your lordship will take it, but we have taken a preliminary objection in regard to suppression of material fact. My lord, why? My lord, I have elaborated that. Your lordship will kindly look into paragraph number, page 239 at paragraph number 4.2.1.
Yes. In paragraph.
That the petitioner has deliberately and knowingly failed to bring on record the material facts and documents filed in the earlier writ petition, that is WPC number 775 of 2020-2025, challenging the same or related issues and which was withdrawn on 24/3/2025, with a liberty to file the instant writ petition before the appropriate forum. The non-annexation of such crucial documents amounts to an abuse of the process of law and an attempt to mislead this honorable court. That in the synopsis of the present writ petition, there is no mention of the earlier writ petition WPC number 775 of 2025 and its outcome. Even in the list of dates, it is merely stated that 11/2/2025, the petitioners being aggrieved by the issuance of the interstate seniority list dated 17/9/2024, instituted in WPC number 775 of 2025, and that on 24/3/2025, the said writ petition was withdrawn. Then in paragraph number 43 of the instant writ petition, my lord, they just makes a cursory reference, and the documents, my lord, which they have not annexed and which are part of the earlier adjudication, that we have marked at paragraph number 4.2.4, 1, 2, 3, 4, 5. All these applications they have not annexed in this present writ petition. So we have taken a preliminary ground that this suppression of material fact.
What about the merits?
Yes. Now, so far the justification of 22(3), my lord, your lordship has seen Patnaik case also. The Patnaik case, the rule is completely different. It doesn't talk about the year of vacancy. Here, the year of vacancy, which it talks in Rule 22(23), is clearly justified by the affidavit of the government. I need not read those paragraphs. Why the promotees were given this in regard to the year of vacancy, why they were given preference. All these respondents, they are on the verge of retirement. Some are going to retire from next. Yes, so this justification which they have given in their affidavit opposition, it supports Rule 2023. And so far the government of Assam is concerned, it is not that this particular rule is in force today. It is in force from long ago. Nobody had challenges. There are other 8-9 departments also, like irrigation department, all where all these rules have been, the similar provision exists, and there is still promotions are made on those rules. Now, so far this vacancy position is concerned, all these vacancies are of 2022, although it is not disputed, but we have given a chart how these vacancies were calculated, my lord. That your lordship will find at paragraph.
That is not in dispute.
Yes. So all these vacancies are of the year 2022. And so far it is challenging the validity of the rule, my lord. I did not hear any argument saying that this rule is manifestly arbitrary. If you challenge a rule, simply stating that it is arbitrary will not do. It has to be manifestly arbitrary. I can rely on the judgments of the Honorable Supreme Court to say that this rule is not manifestly arbitrary to be declared as unconstitutional or ultra vires of the Constitution. Next is, my lord, so far all the rules that my learned friend is referring, or the judgment which was referred earlier, it is ultimately at the end of the day what the service rule says. If the service rule says it is the year of vacancy, my lord, then the year of vacancy has to be calculated. So far the direct recruits are concerned, my lord, the paragraph 34, which was read from Patnaik case, my lord, it talks about the borning of the that persons not born in the cadre. In this case, my lord, the direct recruits were their vacancies were notified in 2019 and they were appointed in 2022. So they cannot have the restorative seniority from 2019 because they were born in the cadre only in 2022. So they will have the seniority from 2022. But Rule 22(3) is very clear that it is the senior, it is in the year which the vacancies occurs. My lord, I'll place only one judgment of the Honorable Supreme Court. In 2022, 6 SCC, page 65, except page. These are familiar law to your lordship, but just for refreshing, I am reading, my lord. 2022 6 SCC, paragraph number 28. It has been further held by this court in the said case that for challenging the subordinate legislation on the ground of arbitrariness, it can only be done when it is found that it is not conformity with the statute or that it offends Article 14 of the Constitution. It has further been held that it cannot be done merely on the ground that it is not reasonable or that it has not taken into account relevant circumstances which the court considers relevant. The judgment of this court in Indian Express Bombay has been followed by three-bench judgment of this court in Kode Distillery Limited versus State of Karnataka. It will be apposite to refer to the following observation of this court in the said case. It is next submitted before us that amended rules are arbitrary, unreasonable, and cause undue hardship and therefore violate Article 14 of the Constitution. Although the protection of Article 19(1)(g) may not be available to the appellants, the rule must undoubtedly satisfy the test of Article 14, which is a guarantee against arbitrary action. However, one must bear in mind that what is being challenged here under Article 14 is not executive action but delegated legislation. The test of arbitrary action which apply to executive actions do not necessarily apply to delegated legislation. In order that delegated legislation can be struck down, such legislation must be manifestly arbitrary, a law which could not be reasonably expected to emanate from an authority delegated with the lawmaking power. This court said that a piece of subordinate legislation does not carry the same degree of immunity which is enjoyed by a statute passed by a competent legislature. A subordinate legislation may be questioned under Article 14 on the ground that it is unreasonable. Unreasonable not in the sense of not being reasonable, but in the sense that it is manifestly arbitrary. Drawing a comparison between the law in England and in India and further observe that in England the judges would say Parliament never intended the authority to make such rule. They are unreasonable and ultra-vires. In India, arbitrariness is not a separate ground since it will come within the embargo of Article 14 of the Constitution. But subordinate legislation must be so arbitrary that it cannot said to be in conflict with the statute or that it offends Article 14 of the Constitution. Then the court has summarized the points in paragraph number 30. The next judgment today.
Yes.
Next, my lord, the judgment which I am referring is 2002 2 SCC 188 Sharma Transport versus Government of AP.
On what point?
Yes.
On what point?
On manifest arbitrariness, my lord.
Manifest arbitrariness and the latest judgment is there. Where is
Yes.
the need of multiplication of?
Yes, sir. So these are all familiar laws to your lordship. I'm just reiterating the law laid down by the Honorable Supreme Court up from the earlier to the latest. Now your lordship will see. So for the large judgment which my learned friend was referring to, the Constitutional Bench judgment, or that 5-judge judgment of 1967. It was
Yes.
even paragraph.
Yes.
Just a moment. My presentation. Just a
SG
moment.
Jay Singhani, yes,
Yes,
it is
yes,
there.
yes.
I give it to you.
Yeah, I'll take his print up. Move it to that. Para 13, man.
Yes.
Your lordship will look at from the middle portion. We are of the opinion.
Line.
I have to count it now. Count it. Having regard to the particular circumstances of this case, we are of the opinion
Sir, which
Just-
line, please?
Just a moment, I have to count it once. Sorry, it is paragraph 8. For more,
We are of the opinion that the fixed quota exercise in their power this.
yes.
Read,
Oh, my lord, in this SCC citation, it is
sir,
correct.
read from here only
Yes.
because we are having.
Yes, yes, I've taken it for, it is paragraph number 8, the first, second, third, fourth, fifth line.
8.
8. 8, next page, my lord. 8 starts. 8, this page number is also not printed. 8 paragraph it starts, then your lordship will go into the next page between the requests coming from the two sources. That is my page number 3 now. Page 7, it is in the top, it is written page 7.
Yes.
Now, fifth line, having regard to the particular circumstance of the case, we are of the opinion that the seniority rule is not unreasonable when read with the quota rule, which provides for a special reservation of a small percentage of posts for the promoters who are selected by a special committee which determines the fitness of the candidates for promotion after they have put in at least 3 years of service as income tax officer. Here also, my lord, the qualifying service was 8 years. Government relaxed it by invoking the relaxation rule, and to give the promoters because of their long years of service in the department. And in terms of rule 2023, the government want to give this promoters who have put in their years of service that it is in the same year, that is in this case the year 2021. In case of direct recruits and promoters, the vacancies are of the year of 2022, then the promoters will be senior to the direct recruits.
Yes.
So to summarize, my lord, so far rule 2023 is concerned, my lord, 2023 is concerned, it is constitutionally valid and it doesn't create a class amongst a class. There have two different sources, and in the judgment also in the Jai Singh's case, I have seen that if it was from the same source, then you can say that if some discrimination has been made. But here the sources are different. 30% source is different, 70% source is different. So you cannot say that this is discriminatory or arbitrary. And the government in their affidavit, the PW department has given a justification why they have calculated it as year of vacancy, including the roster point. And all the judgment which are cited at the bar in regard to that seniority position, which has to be calculated from the date of appointment, that is, it all depends on the service rule. If the service rule says that it is the year of vacancy, then it should be the year of vacancy. That's my respectful submission.
Yes.
Lord, my learned friend, Mr. Nayak, appearing for this state, was referring to Rule 11 and 13 to make a contention that as far as assistant engineer is concerned, it is Rule 11. That's not correct, my lord. Please come to page 203. My lord, ultimately, the procedure is Rule 13, and the promotion order we have annexed, that also is also under Rule 13. Please come to page 203, my lord.
Yes.
Subject to suitability, last sentence, my lord, at page 203.
Yes.
subject to suitability as may be decided, the selection mode board may, and by the appointing authority in consultation with commission, an officer belonging to corresponding cadre of the subordinate engineering grade 1 in the Assam subordinate engineering PW service under government and possessing the qualification as set forth herein below shall be promoted to the cadre of assistant engineer in the manner provided in Rule 13 and 14. So therefore, to say that Rule 13(6) has no relevance in the context of this case is not correct. So the procedure is promotion. This. My learned friend referred to that Jingyani's case. In Jingyani's case, what I find is, every rule has its own language. It has to be decided in the peculiar language used in the act. Now, both my learned friend representing the private respondent of the state has said that we have not made any argument regarding manifest arbitrariness. But if it is arbitrary, it is manifest. Manifest is nothing but a suffix, my lord. Now, here what we are saying is, when it comes to direct recruitment, we can counter seniority from the date of recruitment. And when it comes to promotee, they can count their seniority from the date when they're not even born in the cadre. They're only when, my lord, the vacancy occurs. And therefore, Rule 13(6) has no meaning. Therefore, my lord, what is the object of the rule? Object of the rule cannot be to give undue advantage to the promotees who are not even born in the cadre. So what more manifest arbitrariness is required? Therefore, my lord, it's an open and shut case in my humble submission, where the rule-making authority, perhaps, my lord, never considered the implications of the different rules. A person is not even born in the cadre. Now he is sought to be given seniority. And there is no dispute, my lord. We were recruited on 21/9/22 and they were recruited on 6/1/2023. Leaving aside everything, my lord, the present trend, the preponderance of judicial view of the Supreme Court judgment is very clear, my lord, that the safest course is one when one enters the cadre. We have entered the cadre on 21/9/22. They have entered the cadre on 6/1/23. Therefore, my lord, apparently it is valid by Article 14 and 16. And my lord, this rule which my learned friend referred, there, my lord, what was the basis was promotees recommended by commission would rank senior to direct recruits who completes probation during that year. So how that rule is going to help in our case, my lord? In the facts of our case, what we are trying to project for a lordship's kind consideration is when even a person is not even born in cadre, can he count his seniority? That is the crux. In that view of the matter, my lord, my humble submission is it's a fit case where lordships will stay the operation of the impugn order.
Which is the improved order?
My lord. No, my lord, but
we year 2023.
No, my lord. Pursuant to the learned single judge's order, we filed a representation. Now, representation was rejected. Then we filed a writ petition. Now, my learned friend says about suppression of material fact. Para 43, we have made a statement.
You challenge that before the learned single judge, what you have challenged?
We have challenged that, my lord, the order by which our representation was rejected, as well as the seniority list.
Seniority list, which was published in the year 2023.
Yes.
And this representation was rejected.
And that order also. That
taking
order.
records of Rule
22(3). That's why, my lord, we have to challenge the rule.
Okay. This writ petition is preferred on behalf of the petitioners challenging the validity of essentially challenging the validity of Rule 22 in bracket 3 of the Assam Engineering Public Works in bracket Public Works Department Service Rule 1978, claiming that it is ultra virus to the Constitution of India as well as the provisions of the other provisions of the rules of 1978 itself, particularly rule particularly the rule 2J, rule 6 in bracket 1 in bracket A, rule 6(1)D, rule 13(1), rule 11C, read with article 14 and 16 of the Constitution of India. Full stop. Rule 22(3) of the rules of 1978 reads as under. So rule 22(3) from page 38. Yes. Learned counsel for the petitioners have submitted that the petitioner, has submitted that the petitioners are the direct recruitees and appointed in the cadre of the assistant engineer on 21/7/2022.
9 Millard, September.
27/9.
21/9/20.
21/9/2022.
Yes.
Whereas the private respondents who are the promotees were admittedly promoted on the post of the assistant engineers on 6/1/2023. It is contended that by virtue of rule 22(3) of the rules of 1978, the petitioners, the private respondents were assigned seniority over and above the petitioners, and that is per se illegal. Learned counsel has submitted that when an employee is not even born in the cadre, can't assign the seniority from a date when the vacancy occurs. The learned counsel for the petitioner has placed reliance on the decision of the Honorable Supreme Court rendered in Jagdish Chandra Patnaik and others versus State of Odisha and others, reported in 1998 for SCC 456. It is also contended that against the gradation list published in the year 2023, 2023, the petitioners have referred a writ petition before the writ court, and the said writ petition and in the said writ petition, as per the direction as per the direction given, a representation was filed on behalf of the representation was filed on behalf of the petitioners, raising the grievance regarding the gradation list in which the promotees were assigned seniority over the petitioners. However, the state government by order dated 29/1/2000.
23/9/24. Oh, sorry, 29/1/25. I'm sorry.
29/1/2025 has rejected the said representation, taking recourse of rule 22(3) of the rules of 1978, and therefore the petitioners are forced to challenge the validity of the said rules. Learned counsel for the petitioner has submitted that the rule 22(3) of the rules of 1978 is arbitrary and unconstitutional, and therefore the same is liable to be struck down. He has also argued that the gradation list published by the respondents in respect of the assistant engineers in the year 2022.
I'm very sorry, Millard. That is 17/9/24.
17/9/2000 in the year 2024 is also liable to be set aside. Full stop. Per contra, learned counsel appearing for the respondent state has argued that the rule 22(3) of the rules of 1978 is perfectly is not unconstitutional and is in accordance with the law. Learned counsel has submitted that taking into consideration the long duration of the service rendered by the promotee officers, they are granted seniority over and above the direct recruits when the vacancies pertains in the same year when the vacancy occurs. It is contended that the Rule 22(3) is in the statute book since 1978, and all the departments of the government of Assam are following the said rule for the purpose of granting seniority to the employees, and therefore there is no justification in challenging the same at this stage. Learned counsel for the respondent state has placed reliance on the decision of the Honorable Supreme Court rendered in SG Singhani versus the Union of India, reported in 1967 SCC online, SC 6. Full stop. Learned counsel appearing for the private respondents has supported, has adopted the arguments of the counsel for the state, state, and has further submitted that the writ petition filed by the petitioners is liable to be dismissed on account of suppression of material facts. Learned counsel has also argued that the petitioners have failed to demonstrate that the Rule 22(3) is manifestly arbitrary, and therefore also no interference is called for. Learned counsel for the appellant has placed reliance, the private respondents has placed reliance on the decision of the Honorable Supreme Court rendered in, what is that, 2020? Rendered in Dental Council of India versus Biyani Shikshak Samiti and others, reported in 2022 6 SCC, page 65. Having heard the learned counsel for the parties and after going through the material available on record, we are of the view that matter requires consideration, hence admit no need to issue notice as parties, as the counsel for as the respondents are represented through respective counsels. However, in the facts and circumstances of the case, it is observed that any further promotion made pursuant to the gradation list issued on 17/9/2024 shall remain subject to the decision of this writ petition. We have simply made any prevention exercise made in this so and so will subject to remain subject to
Milord, joining hands with my learned friend Milord, it can be so said, other than this 2106, above them, we have no grievance against them.
Sir, whatever the promotion they'll make to subject to the decision of the writ petition, if it is involved 106, it will cover only on those 106. Yes.
Password method 25.
Milord, can I take little liberty, Milord? There is one item that's a referral matter. It will take some time, some other day, Milord. Item number 35 to 37. There is a difference of opinion between the two learned single judges, my lord. Some other day, Milord.
Okay, in August,
I'm deeply obliged.
yes, Mr.
Well, I appear for 7, 8, and 9 only, madam.
So who are the state has to file and reply why there is a requirement of seeking NOC from the state?
My lord. Well, state, otherwise state is not a party in the present proceeding, my lord. Only the 2 universities are party, my lord. They are challenging the regulation of the, my lord, councils.
Sir,
State is not a party, my lord. I
state
checked.
is not party?
No, my lord. Health department is not a party, my lord.
Essentially, you are challenging that how the state government can ask for this NOC, you're supposed to make state government as party, sir.
Yes, sir. Otherwise we will be the affected party.
Actually, that party is there. State Bank represented by Secretary Health Department.
So, but then
No, nine
health
we-
department secretary.
Come, Bella here.
No, my lord, I've checked it, my lord.
Right,
The party.
second hit to Salwa. So far, I remember.
No, my lord.
National Commission, National Medical Commission,
I am appearing for.
Dental Council, Assam Agriculture, sir, the state is not.
My
Not
lord,
the party, my lord.
he is appearing, he says.
For respondent number 1 and 2, we have been recently engaged as a standing doc. Mr. Kyar has been appointed. So we are appearing for respondent number 1 and 2.
अरे सर वन एंड
Oh,
टू
oh,
है लेकिन
State is not the party, my lord.
no
I've checked.
objection. Registered society has filed legal challenge against the requirement for obtaining a no objection certificate essentially from the state government to establish this requirement of no objection certificate from the state is in which regulations, sir?
My lord, the regulations issued by respondent number 1 to 5.
1 to 5.
Yes.
There is a requirement for
Yes,
seeking
my lord.
NOC. Then you have to reply.
Lord.
So when you are going to file reply?
Not to be engaged recently, a copy of the petition will be sent.
Notice.
Which supplement?
Okay, give one copy, more copy.
Today only.
Lordship, Mr.
Will go,
Yes.
okay.
Notice.
Yeah.
Earlier, Ms. Lion has received a notice, but recently we have been engaged as the standing counsel for national medical.
Okay, man, I will
लेते
give
थे अगर
you.
कॉपी जो पहले के एडवोकेट है मना कर रहे थे क्या आपको?
Lordship, we have informed today.
नहीं, इन चीजों के लिए प्लीज डोंट विद दिस सेरेमनीज यहाँ पे ये कॉपी नहीं मिली ये नहीं मिली क्या बोलेंगे? जब प्राइमरी क्लास के बच्चे होते हैं सर मेरे को कॉपी दी नहीं मेरी कॉपी ले ली व्हाई यू आर कंप्लेनिंग लाइक दिस? Okay, Mr. So and so appearing on behalf of the respondent number 125 has placed some time to file reply to the writ petition explaining the justification of the requirement of seeking NOC from the state government for the purpose of establishing professional college.
But for medical college, dental college and veterinary college.
For medical college,
Dental college,
dental college and
veterinary college, veterinary.
veterinary college. Full stop. A copy of the writ petition be supplied to, along with the annexures be supplied to the council for the respondent number 125. Within a period of 2 days, you supply the copy.
I will give today if you wait some.
Today itself, the response be filed on behalf of the respondent number 125 within a period of 6 weeks. Take your own time.
My lord, that will be adversely affecting me.
They are
So
not going to
I will
file
pray, my lord, your
because
lordship may it.
the 6 weeks, they are not going to file. I'm rest assured.
Then to my lord, your lordship will reduce it as your lordship
See
pleases.
to it.
Let it be 3 weeks, my lord.
I will
Let
be
me-
the college also. Which are the colleges? Medical college,
Medical college, my lord, dental college, veterinary college and nursing college. 4 they want to.
nursing college.
Yes, including nursing.
Yes.
Not Ayurveda.
Ayurveda probably, my lord.
I think Ayurveda also you
Yes.
We have, that has been completed.
Lordship may include Ayurveda also, yes, my lord. Ayurveda also.
Yes.
For hearing, item
My
24.
lord, my prayer, my lord, make it, if you possible, my lord.
Yes, sir, we'll consider it, please.
3 months, 3 weeks, my lord.
May it please your lordship, lordship may kindly.
Sorry, my lord. Take up my daily.
They're not agreeing, so we'll pass an order on minutes. Yeah,
That the lordship, Learned, Register has already submitted in the argument lordship, then we have filed our affidavit.
So this matter was heard by your lordship along with Justice Goswami, no?
वो तो क्या फर्क पड़ता है?
No problem, I have no problem.
Address again,
No
to
problem.
Today, lordship may kindly pick up if
No, no problem. Your lordship can pass an order, my lord.
Next week, my lord. We are going to pass an order on next week. That's all.
Yes, 22nd.
Next week, I will consider.
Lordship, may kindly fix the date after 24th, my lord. Next week, I have some difficulty. Only pass order, Lordship.
Somebody else will come.
Lordship, my lord.
What's the problem?
Lord.
Somebody else will come.
My lord.
On that day also, you are not appeared. You are not appeared. Mr. Sekia has appeared.
Yes,
Yes,
I
yes.
accept it.